So it's not in the terrorism, it's not in the bundle.
I have it.
So if we're looking at paragraph 6, there seems to be two categories of documents that are being requested. The first one relates to combined bundle at 916. And I understand that the documents sought are to do with a provenance of the images here, and in particular if they are derived from a model, CATIA model, then which model is that? I understand that what's been suggested, we go to the next page. I've obviously not had a chance to take factual instructions. Go to the next page, please.
Next page of what?
917.
Yes.
That if you look at the first image, Mr. Mackenzie has enlarged the bottom left-hand side of that image.
Yes, I can understand that, and it's suggested that is a toolbar.
Yes.
Which is a toolbar in the program CATIA.
Yes. So I would say that the first request that I can decide for is to do with documents or models relevant to the provenance of these.
Yes.
And then the second request, which I can make now, if we go to paragraph 8, is to do with a document that appears in the opening bundle, Defender's opening bundle at tab 15. I'll have to request Your Honour to open that.
Yes, I've got that.
So what's being suggested is that this is not in fact, may not in fact be a screenshot of the model sent with the email of the 2nd of March 2017, which occurs at tab 40. So the second request is for documents or models showing the provenance of the screenshot at tab 15. Now, if we understand that that is the specificity that's being requested rather than the very broad brush request being made, then I can take instructions and undertake to update the court by 10 a.m. tomorrow as to whether we agree with it, and if not, why not? And if we do agree with it, what we propose be the way of dealing with the matter.
Yes. Well, Mark, what do you say?
Your Honour, what I say about this is that the order is much more specific than my friend suggests, and it is quite simply that as a result of the evidence for you, we are concerned that the documents at 916 and 917 emanated from a CATIA model that Dr. Affan said he did not create and was not created, and he had no sight of it until the 2nd of March. It was created on the 2nd of March, and the panelization proposals were produced by the 7th of March. This, we say, is untrue, and it's untrue for the reason that Your Lordship, that Your Honour has identified, which is that at the bottom of the top left-hand...
I've not identified any reason why it's untrue. I think that's unfair. What I have seen is a toolbar at the bottom, but it seems to me possible, I'm not trying to guess the evidence, that one can open software models from various different commercial providers within software from other commercial providers. So, for example, it seems to me to be possible, and I don't know without expert evidence on the point, whether or not you can open a Rhino or a Revit drawing in CATIA.
Your Honour, we do have evidence that you can open Rhino in CATIA.
Yes.
We don't have evidence that you can create, indeed we have evidence to the contrary, that you can create a panelization model in Rhino. You need CATIA.
Well, is this a panelization model?
Your Honour, that's what was said. If you go
I thought
to...
the evidence was that the colours were there just to show the curvature.
Well, yes, but if you go to the...
I've got 917.
Can you look at 916? I think it's 916 and 917.
917. Oh, you want me to
Yeah.
go to 916?
Well,
or
it's where
917?
he says we created a panelization model. Or, can you go to the bottom of 917? So it's...
It's 2.1. We have completed a CATIA model of the panel C below with proposed panelization.
Yes. So it's the assertion that they've created a CATIA model with proposed panelization, which couldn't be done otherwise than on CATIA.
So let's assume that Dr. Affan was lying.
Yes.
Where does that...
Where that takes us, he says, is Ms. Kinderland's analysis was flawed because her analysis demonstrated, as you will remember, that the changes in Affan's model created on the 7th of March to the approved model on the 29th of June were minor only, and effectively the defendant's riposte is that Ms. Kinderland starts from the wrong first model because on the 2nd of March, his case is that BAM instructed Affan by the email at tab 14, and tab 14 included, they say, tab 15 of the opening submissions,
Yes.
to produce a panelization that was proposed by the employer's design team.
Yes.
That, on Anne's case, led to the preparation between the 2nd and the 7th of March, for the first time, of a CATIA model of the panelization prepared very swiftly by Affan. And his case goes on that the design team's instructions represented major and unforeseen changes. That account is entirely inconsistent with his having prepared a panelization model to put with his tender proposals on the 25th of January. And if that was done, as he was,
So
that enabled...
let's take it a stage at a time.
Yes.
So what has Ms. Kinderland taken as the base model?
The model that she received on the 7th of March.
Which is...
It's the first model,
It's tab 17.
It's tab 7.
tab 17.
Okay. And tab 17 was where?
If tab 17 is, I haven't checked the reference, if tab 17 is the model of the 7th of March, it was prepared on the 7th of March.
7th of March. So,
And that was
so the 10% figure relies upon the 7th of March
Relies on the 7th of March as the start date.
as the start date. And the suggestion, as I understand it, then is that she should have looked at an earlier model.
The suggestion is that the changes between the 7th of March and the 29th of June may have been only 10% of the panels increasing in size,
Yes.
but that takes the claimant nowhere because, they say, all the instructions, the crucial instructions in this, were given on the 2nd of March,
Yes.
and that represented a radical change in what Affan were required by BAM to do. And what Mr. Smith says is that 70% odd of the panels increased in size.
Yeah.
And that isn't taking as a start of the 7th of March.
Yes. But that's always been the case, isn't it? I mean, that's always
Yes, but what we haven't had, and what Dr. Affan gave evidence about, was these pictures not being in play on the the panelisation programme, and any CATIA model, any use of CATIA in respect of MOTF being in play on the 25th of January when the tender proposals were put forward. And the importance of that is that what Affan was saying on the 25th of January was that they had made a model. He said that was wrong. He then said, as you will remember, and that's in the transcript extract next to Mr. Mackenzie's statement, he said that that was done to impress the architect, that they were likely to do a thorough job, and so on and so forth.
To use the old expression, puffing.
Yes.
Or to use a more modern expression, bigging himself up.
Yes.
Yes.
But the importance of it is that there was a CATIA model in existence. And our application is very limited because I don't want to read more into the evidence we have than is apparent on the face. I say that we are entitled as a result, and also as a result actually of the addendum, because Your Honour will remember that paragraph 9 of the addendum, that's B9, which is at page 1967, required the subcontractor to make available key staff or their alternates who are experienced in the use of relevant software and related passwords necessary for completion of the subcontract works. Provisions fundamental, and it continues. These rights and obligations shall continue until the subcontractor is released from such obligations by the contractor in writing.
So, I mean, basically, you'd like to see the CATIA model.
We want the CATIA model. Reason that.
And you'll see the revisions to it.
Yes, and we'll see the data creation.
Yes.
And that is of crucial importance to this case because of the evidence that there has been, because of the evidence that Dr. Affan has given, and because of the principal issues in the case. And our understanding, and this is on instructions from our experts, is that every CATIA file, when opened, will reveal the development history of the model.
Yes, I can imagine.
And while we believe and understand that BAM has some CATIA files, and the metadata of those may well enable the development history to be revealed. Presently, we have no access to the license, the passwords, and the codes, to all of which we are still entitled under the addendum because there's been no such release. Though that may take second place to the interests of justice in providing access to the CATIA model because it illuminates these issues in a way that does assist in disposing of the case justly and dealing with the case justly.
Okay.
And once we have that developmental history, then we can see how far we can take these submissions. If it were to turn out that there's an entirely innocent explanation, Your Honour is asked to accept the explanations given by Dr. Affan, and Your Honour is persuaded to do that, so be it. If, on the other hand, it shows that the CATIA model was created before the 25th of January, as the tender proposal stated that it was, then that is something of great importance to the case.
Well, yes, that would tend to support the case, of course. Then there was a substantial change from the drawings that were sent on the 2nd of March, wasn't it?
Well,
because if assuming Dr. Affan was not telling the truth, and they had produced their own CATIA model on the 25th of January, they would then have received the model on the 2nd of March, which brought changes to that model.
if they did. The difficulty with that is that Mr. Hussein's admissions depend upon the assertion that the model provided on the 25th of, provided on the 2nd of March in that email included icons, and he has
sorry, what do you mean included icons?
included ones of the various, including programs, their building information models, BIMs.
Yes.
And those are said to have included tab 15.
Yes.
Tab 15 turns out not to be the icon that was attached under the same number at tab 14, which is the email.
Sure. Actually, I'm not sure that's right.
Well, Your Honour, that's the state of the evidence now.
No,
Should it be...
I mean, in fact, if you go to page 1091 and have a look there at item 116, I'll just get it out. Item 116.
1091 on the screen, please.
Sorry, I haven't had time to log in, so I don't know what we've got on the screen.
At the moment we've got 917, but we're going to get 1091 in a moment.
Get 1091 up.
So if that can be rotated,
You have it.
I do now, Your Honour, yes.
Okay, so you'll see that item 116
Yes,
is a Revit model.
yes.
And indeed, I think if you go into tab
Yes,
and you go to the last page, you'll see that I assume this is a copy of the Aconex transmission. The Aconex transmission shows the drawing to be drawn in Revit, and if you go over to the very final page, that appears to be a printout of the Revit drawing. Now, if one goes to the exhibit to this witness statement, so it's not the exhibit. It's actually within the witness statement itself. The suggestion that somehow the document is different is based upon opening that document in two different versions of Rhino, in Rhino 7 and Rhino 8. The first on the left side is opened in Rhino 7, the second in Rhino 8. I've not seen the version on the left-hand side before, I don't think it's in evidence. But at the moment, I am profoundly confused as to what your case precisely is about this, because clearly when you open up a document in one version of software, it's going to look one way, and when you open it in another version of different software, it's going to look another way. So at the moment, I have a very strong feeling that you're adding 2 and 2 and getting 5.
Well, Your Honour, I hope not, because they don't have an equivalence.
But the suggestion
However,
that somehow this document, the files are different, at the moment I'm not persuaded of.
Your Honour, can I make a couple of points?
Yes, of course.
First of all, my understanding is that Rhino 8 was introduced in late November of 2003. So that's new. Secondly,
And where's the evidence of that?
well, I'm telling you all instructions, I found that out this morning, in attempting to find out what these volumes show. Tab 15 is relied upon by Mr. Hussein, and the point I've just made is an important point in relation to this, because if that was only, Rhino 8 was only created in late 2023, that's an important point that we need to
Why is it-
investigate.
Well, it just means that whoever's printed this out
Has opened it in January 8, of course.
And I can tell you that this screenshot at tab 15 was taken the week before the hearing on my instructions. So it was taken using whatever software was available in the personnel's computer at the time. I'm not sure.
Well, that may
what's
be, but
suggested.
we're not seeking to speculate about this. What I am seeking to do is to invite you to the conclusion that the document on the right-hand side of the two images of the tab 14 and tab 15 model, in the body of Mr. Mackenzie's witness statement under paragraph 10, show prima facie two different models.
Well, I don't know that.
First of all, I'm not inviting Your Honour to know it. I'm inviting you to make an order that we get to see the CATIA model so that we can trace this.
But this is not about the CATIA model now, is it? This is about the annex to the annex to the email of the 2nd of March. There seems to be some suggestion that has been produced to me as the annex to the email of the 2nd of March is not genuine. That's what I understand your application to be.
The application is quite simply to look to see the CATIA model. Because
So
our
this
understanding...
has nothing to do with the CATIA model.
Well, Your Honour, it is in the way that the case has been put and in the way that Dr. Affan gave his evidence. He gave his evidence to the effect that the email of the 2nd of March, which he said exhibited tab 15,
Yeah.
caused a flurry of activity between the 2nd and the 7th of March, which involved the creation of the panelization model. Tab 14, which is the email of the 2nd of March, was said to include, this is important, tab 15 because of the existence of the same numbers.
Sorry.
I'm getting totally lost here. Is it suggested that what has been produced to is not is what was annexed to the email of the 2nd of March?
That's what it looks like.
Well, I'd need persuading with that.
If it helps you,
Because it's being opened in different software. So I don't know how software opens drawings made in different software.
We're on a, can I, but tab 8, page 8 of tab 14, of which the court has a soft copy, I understand, be opened. That's tab 14 of my friend's opening bundles.
Yes, so that's the Revit model. Is it?
zoom in to the top.
And if you can zoom into the top middle for the number.
Sorry, so what am I suppose I better get up the... I better get
Your Honour,
the
yes.
line. Bear with me while I get to see what you're looking at. Ali, do you have any Ruth sent me, but he sent me actually the transcript. That's the transcript. So where's the team? So I go back to the old one. Let's just see if I get it on the old Okay, right, let's get everything out here. I have to go back to the chat. All right. Okay. So that's the meeting. That's, I've got it in now. Oh, ask to it. Can you just ask it?
That's the exit.
Okay. Thank you very, very much, Jan. Okay. So I have in soft copy what I've been looking at in hard copy.
Ronald, that's helpful. Can I simply introduce what we say are the key facts?
Yes.
Tab 15, which my learned friend opened as the document that was attached, tab. And his case is that that was part of the instructions given by BAM to Affan.
So we have a drawing number on there.
That drawing number is different. Can we
You're
zoom in on the?
drawing, it's a
Can we zoom in on
screenshot
tab
of a
15?
model.
Yes, the screenshot with the model number appears.
Yes.
The file appears at top left corner.
Yes, and that is BIM. Looking at the last ones, BIM 00001 hyphen 0003D, and it's the second copy.
Yes.
And it's
that
3149.
That is the same as item 116 on 1091.
But that is not tab 15. That's your point.
I'm sorry, that is not tab.
Yeah.
What do you mean that is not tab 15?
If you open, yes, the point is that Mr. Mackenzie is making in his witness statement is that when you open the file with that number
Yes.
in tab 14, which is the 2nd of March email,
Yes.
you do not get this image. You get a different file.
Yes. Sorry.
Not, no, you get a different file from the left-hand file.
No. This image, I don't know whether this image is an image you can toggle through or forms part of that model. What I do see is a file name. I see the same file name in the documents. I see the same file name attached to the email. What I don't know, and what I need expert evidence on, if it's serious, this is seriously going to be pursued, is how you can manipulate what you see on screen by the software. So I don't know whether this view is a view that you see in Rhino 8 as compared to a view that you see in Revit or Rhino 7.
So, Your Honour, what we can say, and this is really why we need access to the CAT model, or one of the reasons why we need CAT model.
But this is not. But we're not discussing the CAT model now. We're discussing the file that's annexed to the
But
email.
the
And you're telling me that I've been given a false image of that file.
Your Honour,
which is
yes.
Extremely serious.
Because Ms. Kinderlam has been through the image number in tab 14 attached to the 2nd of March. She's generated all the images that can be generated, and tab 15 does not appear within
You're
tab
telling me
14.
that.
Your Honour, yes, and I need expert evidence, which is part of the order that I seek.
That's not Mr. Mackenzie's statement, what you just said.
It's not in the Kansas
Just
state.
same stuff. Why is that not on the page?
Because it's plain as day.
Oh, right. You're an expert.
I think if we could...
I am deeply confused. First of all, I don't know in Mr. McKenzie's statement what the image on the left is meant to be.
The image on the left comes from tab 14 when you open up the number of the Rhino model
In Rhino 7.
in Rhino 7,
Okay.
the building information model ending in 3D,
Right.
and that's in Rhino 7 commercial software.
Okay.
And that we know.
Okay. All right.
Nowhere in that process, if you continue to search any images that are generated by that model number
In that software.
in that software, or in, yes, we haven't used the CATIA software.
No,
Do you
haven't
get?
used Rhino 8 either.
No, I don't. I'll just check that. Did you check?
But it says Rhino 7 at the top.
No, we've only used Rhino 7.
Correct.
Nowhere has Ms. Kinderlan been able to, or has she found, the image on the right-hand side of the mistake
So
in that
both
model
are-
number.
both
And
are-
indeed the numbers.
Both parties have access to the original file.
Yes.
So the only issue is whether or not tab 15 is generated from the original file using Rhino 8 software. That's the only issue for me. Isn't it?
I'm not sure that it is, because although Mr. Hussain tells us that he opened this in Rhino 8 the week before the hearing, his case was that the instructions to Affan were contained in the email of the 2nd of March, and that they included the image in tab 15. In other words, his whole case has been put on the basis that tab 14 included tab 15.
Yeah.
And the analysis and the discussion we've had this morning.
But it's common ground that tab 14 included this file. I mean, that's not an issue.
Included the left-hand file, yes.
No. You're confusing files and images. They are both images of the same file.
Well, no, I don't think we are confusing it. I think the points we're making is that there appear to be two files by the same number.
There's also a timeline issue here that Rhino that existed at the time this image was supposed to be generated.
So you're suggesting that tab 15 comes from a different file from that was attached to...
Exactly.
That's your suggestion.
There's another position here, there's another point here, which is that I've told you that Rhino 8 was introduced in the end of 2023. Rhino, we're not sure of Rhino, and we need expert evidence. It appears likely that it was Rhino 4 or 5 back in March 2017. But that's not something on which I'm in a position to give any evidence.
We can resolve this fairly easily, can't we? Because the original file is available, and surely the experts can just sit down together and open it in Rhino 7 and Rhino 8, and then I can be told whether or not this is a genuine image generated from that file.
Well, that's precisely what Marina's done insofar as she's got Marina Kinderland has done insofar as she's got the software available. However, that doesn't impact on my central application, which is to have access to the CATIA model.
That's a different, but you keep on going back to the
I do,
different
yes.
issue. we're just dealing with this image at the moment. I understand the submission on the category.
Your Honour, I appreciate.
And I'm not wholly unsympathetic to it. It's this that I'm concerned about, because this in many ways is a more serious allegation. Because what you're telling me is this is not a genuine document.
It's not a document. What I'm telling you is there are very strong reasons to suppose that it is not a document that was generated by anything in the 2nd March email.
Yeah,
Crucial for this
that
case.
That means that since it purports to be, you're telling me that somebody is producing to me a document which is not genuine.
That is the inference that we provisionally draw at this
understand.
moment.
So the simplest solution to that is that the 2 architectural experts sit down, it seems to me, with Rhino 7 and Rhino 8 and open the file.
No, no, that's certainly a starting point, but it goes further than that.
Well, you make
because
your submissions after that, but I'm only concerned at the moment with the integrity of the evidence. You can make your submissions
yes,
once we know what the evidence is.
well, I appreciate that. But if I can simply foreshadow a submission, the evidence that you have heard that Affan's and Dr. Affan in particular works in Katia, that he used this document in tab 15, which he received as an exhibit to tab 14, in order to assist in producing the panelization. And that, on the basis of the instructions he received on the 2nd of March, in the email of the 2nd of March, was what generated the change of instructions.
Yeah.
And it's as straight as that story. It's much more complicated, I entirely accept, when it comes to analysing the expert evidence that will be needed to establish or disprove it. I appreciate that it may be as simple as sitting down and opening tab 14 and seeing if we can find tab 15 out of it, and opening in the relevant software. That I understand. But I mean, one of the points is that the document that's now come up on the screen doesn't appear to have panelization in it.
Well, what's on the screen is I assume, the original Revit drawing.
Yes, from tab 14.
Yes. I don't know what software it's been opened in.
I think it is Revit, is it? Yes,
Well,
it's Revit.
I don't possess your expertise.
But I'm lucky enough to have experts sitting behind me who do. I have none of the expertise. I'm merely relaying the position. But what I am submitting in terms of the just disposal of this case is that this can only be sorted out with the assistance of the order we seek, which in relation to Katia is disclosure of the Katia model and access to the Katia model, including all the passwords necessary to access it. Dr. Affan used and relied upon the Katia model in order to produce the panelization upon which he relies for his case on variation. So that seeing the development history of these documents is very important. It will show, one hopes, that if this document was opened in Katia from whatever source, then it may or may not have been used in the production of what he says, and we need to know the date in respect of which it was used.
We're going over all ground. I mean, it seems to me, I'll hear Mr. Hussain in a moment, but where I am at, pending Mr. Hussain's observations, is I can see that you've raised an arguable application to see the Katia model. So far as these two documents or two images are concerned, at the moment I'm far from persuaded that there's anything sinister about it. But the solution seems to me to be very simple, that the experts sit down with the original file, which is available, and they open it up together in Rhino 7 and 8, if those are available, to see whether or not one can generate an image such as appears in tab 15.
Your Honour, that's a sensible and informal suggestion, if I may say so.
Well,
However,
it may not be an informal one. It may
no,
actually form the basis
it can form a basis of an order. I appreciate that. But if I can take you back to the order, Your Honour will remember that on Friday evening I addressed you on the basis that this account of the variation was entirely new. It was unpleaded by the defendants. It did not feature at all in evidence submitted on their behalf, neither the lay evidence nor the evidence submitted by Mr. Smith as the technical expert. And I submitted, therefore, that it ought to be pleaded. And that is the subject of paragraph 2 of the order, which I've put in very much with a view to not disrupting or to avoiding disruption of the programme. I then suggested that we should respond to that by the 11th of November. And then at 4, the parties are to file any evidence in support of and limited to the amendments made by the 4th of, by 4 p.m. on the 15th of November, together with any documentary evidence they seek to rely on. The discussion we've just been having about tab 14 and tab 15 falls, and I quite accept from Your Honour that it falls much more clearly into concern for paragraphs 2 to 4 of the order than it does into paragraph 1 of the order. And I quite accept that the evidence, not just accept, I rely upon the fact that the evidence that we need to see and that we need to call, and you said on Friday night I should tell you what that evidence would be, it will be in relation to the Katia model, evidence from an expert whom we have already identified over the weekend, who will be able to give evidence about the working.
You'll be asking permission to call a new expert.
The working of the Katia model, so I will. It's relatively simple evidence. It's just about the working of the Katia model, the tracing of the development history, and I hope that can be done very fast, and I hope that can either be agreed because it is, but it will be controversial to anybody who knows about Katia. The second expert will, I hope, the second category of expert evidence will be that given by Ms. Kinderland, who will have to produce some evidence, both on the opening up of the images in tab 14 and tab 15, and on what the Katia model tells her about the availability of the panelization program and what the developmental history that the first experts can say about the development of the panelization program. That will give the court the information the court needs in order to determine whether the flurry of activity between the 2nd and the 7th of March 2017 to produce the new panelization models on instructions from Bound to Affan is a credible account or not. If it isn't a credible account...
It was always the case that a model existed before the 2nd of March.
Not a panelization model. That's not what Dr. Affan said at all.
I'm sorry.
He was working on a model, and he said that it would only be available, I think, 7th of March.
Okay,
And he said two things which haven't been completely explored. One, there are documents to the effect that he was working on panelization at the end of February. But the panelization as a result of the varied instructions was all done, he says, between the 2nd and 7th of March. And that's his case now on the big change. And Your Honour will remember that I drew...
his case now, but I'm sorry to talk across Mr. Smith, but it's Mr. Smith's evidence that Ms. Kentland used the wrong base, and he used a different base. You've always known that Mr. Smith has taken a different base for the calculation of the changes.
Yes, because Ms. Kinderland takes the 2nd of March base,
Yes,
the 7th of March
but
base.
it's always been clear in Mr. Smith's evidence he takes a different base.
Oh yes, he takes a completely. I mean, I haven't cross-examined Mr. Smith yet, but I'm going to,
Yeah.
and we'll elucidate
So
where
I
his
don't
70% comes
understand where
from.
the surprise lies.
That's not the surprise. The surprise is that they changed their case in order to undermine Ms. Kinderland's analysis of the change from the 7th of March to the 29th of June.
I don't understand that point. Because
I don't understand the riposte to it.
I'm sorry. Actually, Mr. I'm going to ask you to leave the room.
Okay.
We're going to be discussing your evidence.
No
I
problem.
don't want any sense that it's tainted by what we're discussing. Thank you. Look, if we go to Mr. Smith's second report, and we'll find that in the electronic bundle, second report is 14, and then supplementary report of A. Smith, 5th of July, 2024. And then if we go to PDF page 20, within that report, paragraph 7.1.2, the AESG report stated it would assess the panel size in AEIS's tender against the IFC document as per section 4.2 above. Panel size in AIS's tender appears to have been ignored in AESG's analysis. It's unclear to me why the IFC document set would be used as this is provided to AIS post-contract award. Furthermore, AESG's model analysis is between two post-contract models, with no discussion as to whether the first model produced with panel sizes in the proposal included a requirement of mechanical fixing stainless steel sheets to GOP. This is not prohibited. Then we go to 7.2.1. In my previous report, I opined that the increase in panel size was likely dictated by the consultant or the client team, but I considered it a factual matter for the court to decide. Ms. Kinderland does not address this in the report. Instead, she reports on whether the panels have increased in size, comparing the first post-contract model with the final approved model. Ms. Kinderland acknowledged the AES tender was based on panel size 9 by 2.2, but as no model was provided as part of the tender return, she appears to ignore it. Instead, she concluded based on comparison of the first post-contract model with the final approved model, only 10% of the panels increased. I disagree with the use of the first post-contract model as a basis for comparison. Comparing the size of panels in the spreadsheet provided by AIES with the size stated in the tender proposal, I noted an increase in size of approximately 73%. So it was known from the outset that Mr. Smith has disagreed with the use of the model that Ms. Kinderland uses to generate the 10%.
Indeed we have. But that doesn't alter the fact that we have a fundamental difference with Mr. Smith, and it's probably as well that he's out of the room for this moment, because he has analysed to get to his 70% or 73%, and that's at 512.
I accept you have differences with him, and that's what we're here to resolve. But what I'm trying to understand is the suggestion that somehow it came as a surprise to you when Mr. Hussain cross-examined Ms. Kinderland on the basis that she was using the wrong model.
Can I answer that?
Yes, of course.
First, by finishing my first point. Our dispute with Mr. Smith's evidence is that he only looked at 9 by 2 as the maximum size and we will attempt in cross-examination to demonstrate how that cannot have been right, and that the sizes can be considerably greater than that, and that they are in fact closer to the what Ms. Kinderland calls the option 1B sizes. They be more, and we're just talking about the nominal size.
Yeah,
that leads to his 70% increase. The difference that Your Honour is pointing out to me is that Mr. Smith has a criticism of the use of the first contract model.
yeah.
If there were a pleading and evidence to the effect that between the second March, which was the acceptance, we'll come back to that, which was the letter of intent, and the 7th of March, which was the first post-contract model, there was a change, then Mr. Smith's position would have some validity. The pleaded case was that what changed on the 13th of March. As it happens, we now know from a document that's been discovered that the letter of intent only accepted on the 8th of March. I didn't know about that document. I didn't put it to Dr. Affan. But that's the document that we will be seeking to introduce. It has
So
this,
this is just going way beyond. There's just new applications being just laid out.
I'm not making an application. I saw this document in the early hours of this morning.
No,
I'm
Mr.
simply...
Zain, I'll give you your chance in a moment.
Had there therefore been a change between the 2nd of instructions, or a variation between the 2nd and the 7th of March, Mr. Smith's criticism might have weight. As it was, the pleaded case we faced was that everything changed on the 9th of March. In those senses, there having been no change between the 2nd and the 7th of March, we rely on Ms. Kinderland's analysis to show no change between the 2nd and the 7th of March, letter of intent on the 2nd of March. Thereafter, the first model is the 7th of March. That's a model that you can take as having subsisted from the 2nd of March, and that subsists all the way through with changes that both experts agree are minor until the 29th of June, and that's the final approved model. That is the area of difference, and that's why I say the fact that this case wasn't pleaded in the way that it's now put, and the fact that it wasn't evidenced in any of the witness statements or the other evidence as showing a change between the 2nd and the 7th, brings the criticism of Ms. Kinderland's evidence into play, which it was not. Because the answer to the criticism of Ms. Kinderland, you're using the first post-contract model 5 days after the letter of intent, was, so what? Nothing changed. Sorry to use the vernacular. The answer now is we have to rebut the proposition that everything changed between the 2nd and 7th of March, which is an entirely new case.
I understand the point.
And that is why these documents, their provenance and their relationship to the email of the 2nd of March, and the editor found that the instructions and the opening of the case on the basis that the right-hand document was included in the email of the 2nd of March is of such importance.
Yes, I follow.
Ronald, I think I've probably gone as far as I wish to on the facts. I don't know whether Your Honour would want to discuss the order that I seek with me at any stage.
Let me just take, let's say, I just want to hear Mr. Hussain. I know he's anxious to speak. And,
Putting it nicely, yes.
I think he ought to have an opportunity to state his position.
Your Honour,
So,
far be it from me to try and dissuade you from that.
No. Mr. Hussain.
You know, I'm just going, there's so many things being said, some of them at the top, that I'm just going to try and deal with one thing at a time. So we received this morning in a ex parte, closed door manner, an application for a draft order, accompanied by the second witness statement of Mr. Mackenzie. I'm going to deal first with item 1 in that draft order, which is an application for access to documents. Now, I said to you when we returned after the agenda that I would take instructions and that by 10 a.m. tomorrow we would respond with what we propose. And that my understanding was that from Mr. Mackenzie's witness evidence, there were 2 documents for the provenance of which was requested to be addressed. The colleges at page 916 and 917 of the combined bundle and the provenance of the screenshot at tab 15. Given that I offered to reply by 10 a.m. tomorrow, I'm not sure what more is being asked for. I'm not sure if it's been suggested to you that you should proceed to make an order before I can take instructions and make my proposal.
Yeah.
If that is being suggested to you, I would say that that is not required.
Well, look, you've heard what I said to Lord Marr. I'm fairly sympathetic to the suggestion that that you disclose the Katia model.
Yes, I'll come to that in a moment because I don't quite understand what. If you look at 916, let's deal with the 2. So if we look, one is the provenance of the colour, and the other one is the provenance of. So if we deal with the provenance of the coloured image, was at 916. We go to combined bundle 916. Please. So if we look at this document, it suggested that there was a model which is the basis for this coloured image. But the same document in the next page says in terms, the panels will be formed from advanced fibre layouts and bonded with fire-rated items. The panels of main facade are proposed to be 9 by 2.2 metres. So I'm still struggling to see, this has never been clear, what the significance of these images, and even if there were the product of the Katia model is said to be. It just seems to be a general point as to credibility, as to why they were suggested to be a Katia model or not. So that's the first point, and I will take instructions on the provenance of this image, and I will come back to yourself.
Sure. And you know, it may well be, again, I'm not here, it may well be that there is an underlying model that was opened in Katia and coloured in Katia.
Yes, but none of that, and I don't want to give you information that I'm not to. None of that automatically means that the Katia model used for the works should be opened up. There's no connection between these 2 things. Let me take instructions and I will.
But what I think may be likely is the Katia model updates itself, and you'll have to look at.
I'll need to take instructions.
Yeah.
Yes. So that's the first point. I'm not sure where this is meant to be going, other than a general credibility point, either on the main proposal or on Dr. Affan, which is a matter of submission. So the second point is the document at opening bundle tab 15.
I regard that as a more serious allegation.
Yeah, well, I find it quite strange. I mean, again, with respect, the proper thing to do, and this is in a context of other conduct of the claimant of its case, the proper thing in my submission to do would have been to write to my solicitors and say, we would like documents showing the provenance of X, Y, Z. Can you give it to us by X, Y, Z stage? So what we had was, in my submission, a quite sensationalist approach, that documents will be destroyed, etc., without any evidential basis. But we are where we are. So now, it's been suggested that the document at tab 15 does not look like the document when, now I understand, this is not in Mr. Mackenzie's evidence, when Miss Kindlen opens the file. What hasn't been suggested, the reason we're referring to the screenshot isn't because of what it looks like. I'm not particularly concerned with what it looks like. It's to do with the fact that panels. Now, it's not being suggested that Ms. Kindlen opened the document and it shows a different panel sizing, or doesn't show panel sizing. Maybe that's something that we'll hear next. So the question then is, what is the panel sizing, if any, indicated on the models provided on the 2nd of March 2017? There is nothing stopping the claimant from checking that and giving you evidence on it. They have the email. The email came from them. So it's not about, it's not a particular mystery as to why this looks this way and we need an expert to see if this. I mean, the point is, did send on the 2nd of March 2017 the panel sizes that were larger than 9 by 2.2. That is what I'm relying on this for. I'm not particularly concerned with what it looks like when you open it, etc. But again, Your Honour, all I can say to you is that I will take instructions and come back by 10 a.m. tomorrow. We propose should be done.
Yes, I mean, it seems to me that if there's any, the file says what it says, and the experts acting independently can both sit down together and agree what the file says.
Yes, and this could have been done, I would suggest, the right way to do it would have been to do that before making an application, making all sorts of
That may well be.
but that's not the central issue before you. The other point is to do with the procedural amendments. I just want to be slightly, and this also goes to how wide the disclosures. We do have a concern, and this is linked to the way this claim has been conducted. I do maintain that the dishonesty claim against against the second defendant is not properly thought out, and that has been borne out by the way that these proceedings it's been pursued in the evidentiary.
It wasn't, and it wasn't put in terms that it wasn't.
It wasn't, yes. And what I'm saying is that this is a pattern of conduct by the claimant. I mean the lay claimant. I'm not suggesting anything improper otherwise, of trying to be as disruptive as possible. So I would urge caution in saying, well, they need all the CATIA model, because I can't see what 916-917, which is a January 2017 document, has to do with every iteration of the CATIA model. Obviously,
well, I agree. I mean, if it is possible within the software to isolate the generation of the image that appears at 917, assuming that was generated by CATIA, then I'd be content that any disclosure was limited to that, because that's all that's been asked.
let me see what I can propose, Your Honour, in light of that. I don't want to say any further. I mean, sorry, I would just be getting into beyond what
so
issues.
look.
So I propose to get back to you by 10 a.m. tomorrow with a proposal on what I understand to be the two key issues: the
Yes.
provenance of 916 and 917, and what, if any, disclosure we propose to make to satisfy that, and the provenance of the document at item 15 of the open document.
Okay. Lord Marks, I think we have to wait upon Mr. Hussain. He may consider.
Oh, yes.
And so, in terms of how we proceed, I'm anxious that we use the time that we have constructively. We will now move to the cross-examination of Mr. Smith. Tomorrow morning at 8:30 for site view, and at o'clock we will resume, and Mr. Hussain will tell us what disclosure the defendants are offering. You both heard my preliminary views. Just to reiterate, I am sympathetic to your application in relation to the CATIA model insofar as it was used to generate the images at page 917. And so far as tabs 14 and 15 of the opening bundle are concerned, it seems to me the simple resolution is simply open the file for us to agree what it says.
Can I respond a little more widely?
If you want.
As quickly as I can.
Okay.
Well, first of all, the way Mr. Hussain addressed you completely ignores the fact that we had no sight of tab 14, no sight of tab 15 until he opened the case.
None of documents.
There are documents in the sense that in a whole welter of documents they were from somewhere. Tab 15 it's not clear at all that the provenance of tab 15. Tab 14 I accept was in an email sent by BAN to Affan. I completely accept that. All it is issued for instruction.
But honestly, I'm not at this stage interested in the submissions as made on the back of these documents. I'm just interested in, in the disclosure act.
It's just that the next point that goes it possible simply to deal with it by the two experts sitting down. But the two experts may need to give some evidence in relation to that.
Well, if that happens, I should say that I am currently minded, as I indicated in the PTR, to witness conference.
Yes.
The two experts. Indeed, this is something that may be dealt with during that witness conferencing. Had we not had the diversion that we've had this morning, I would have thought that we may well have finished all of the evidence either or by lunchtime tomorrow.
Oh, yes.
And then I was minded to spend an hour or so with the two architectural experts, basically running through as an agenda their joint statement. Because, again, I hope it's helpful to both parties. But what I wanted to focus on with you on the feasibility of the original proposal by Affan and the fixing of the panels, in particular reference to the hexagonalization.
Oh, yes.
So those are the issues that I wanted to discuss with the experts, and I mean discuss in terms of
yes.
witness conference.
Right, can I just inquire first whether the view has been ranged?
I think that's, Ali, do we know yet whether it's been finally? By the end of today, will we? Okay. I'm told they were quite optimistic. Let's assume it's going.
Yes, thank you. The other problem is that if we're not going to know till tomorrow morning whether we're going to get a disclosure in relation to the Katia model, I appreciate Your Honour has separated them out. This can probably have been needed. I don't know whether it might be possible, rather than doing this at 2 o'clock tomorrow, to do this remotely as well with the two experts when everybody's had a chance to consider it and they've had a chance to discuss it.
I'll have a think about it, but I'm very anxious that that we get on and that we don't delay.
Well, no, so am I. The other point is that Mr. Hussain suggested, and you tended to agree with him, I think, that I hadn't put the case on the 3 allegations of dishonesty against Dr. Affan, squarely to Dr. Affan. I hope that I did.
Well, that will be a matter of submission.
That will be a matter of submission and looking at the transcript, but certainly they are maintained, and I may have been too polite to him. But I don't know.
Well, it's not a question of politeness. I need to put down the record. I will be taking the point that it was not put to the allegations that the act of dishonesty, and I will be taking the point that if and to the extent the case could have properly been maintained before the cross-examination, which I said couldn't, it shouldn't properly be maintained now. Just want to get that on.
That's the, as I said, those will be matters of submission. I will review the transcript and clearly have to come to a decision on
yes, of course. Your Honour, so be it, and Mr. Smith can perhaps
So shall
come back.
we now then, in the last half an hour before the lunch adjournment, get Mr. Smith back so he can give you a crossing?
Your Honour, certainly. Would you be happy to sit till 5 o'clock today? Okay.
I had the Swiss bar visiting this afternoon.
Your Honour, so be it.
Having said that, they are coming to observe part of the case, so maybe if you allow me just to speak to them at 4:30 and ask them whether they'd be quite happy to listen to another half an hour of the case.
Of course.
So it's not an unqualified no. I'm sure they'd be fascinated. So
Well, that's very helpful, thank you.
Sorry about that,
Okay.
Mr. Smith. So,
Mr.
Lord Marks is now going to begin his cross-examination.
Mr. Smith, I'm sorry you've been kept waiting for a rather long time while we've been dealing with other matters. But I'd like you, please, to look at your slides from your presentation. And you'll find those, I think, in the updated electronic bundle that's now there. I'd like you, please, to look at slide 2. On the right-hand side, you'll see that option 1 is for a 2.5 metre maximum, 2 metre optimal, 4.5 metre optimal height, 5 metre maximum, 6 metre maximum height. And the right-hand option is for the 22 metre maximum, the 9 metre optimal, and the 3 metre optimal, and the 4 metre maximum on the right-hand side. Those reflect Ms. Kinderland's slide 9 to 11, and I expect you'll appreciate that that was the panel size that the IFC documents required.
Dependent on the contractor's design, yes.
Yes. Contractor to choose, we all accept, means the subcontractor to choose in the text of a subcontracted facade package. Would you go, please, to slide 3? So the top shows some panelization, and the note 3 can go down, please. The panels there are said to be single curved panels with limited of minimal double curvature. Is that correct?
Yes.
And if we go to page 862 of the combined bundle, we see the tender proposal said was advanced structural composite facade panels, double curved, with a nominal size of 9 by 2 by 2.
Correct.
Was the idea then still to keep the double curvature to a minimum?
I wouldn't know that.
Would you go back to your, well, would you go to 917? That shows a smooth surface.
Yes.
Is that correct? And I suggest to you that the point of the double curvature is to achieve the smooth surface so that the joints between the panels don't need to be faceted.
Correct.
Go forward, please, to your slide 5. You have drawn on the right-hand side, you put a red box around the tender proposal. You've put 9 by 2 by 2 as compliance, double curved elements, and you've put 9 by 2.2 for every single panel.
I haven't put 9 by 2.2.
Right.
That is what is in Affan's tender proposal when they're
Yes.
stating compliance with 901.
And you have,
I've just highlighted it to his honour.
yes, I suspect rather than put, I meant highlighted. Would you?
Sorry to interrupt. This is from Terrace. Can we request the witness to either speak closer to the mic or just check if the mic is on, please? Thank you.
Okay.
Would you look back, please, at your slide 3? On the right-hand side, you've included a quote from BAM's CCN 222, at page 2.
Yes.
It's right, isn't it, that you have quoted from that document extensively?
Correct.
Indeed, in slides 3, 8, 13, 15, 16, 19, and 20. I needn't ask you to look them up at this stage. You hadn't seen CCN 222 before this hearing, had you?
Correct.
So that is plainly a factual matter, that was what was CCN 222, and it postdates the tender by some way.
Correct.
And so that factual matter cannot have contributed to your expert opinion in any way.
Correct.
Would you look, please, at slide 4? And do you see at Coltai's, on Coltai document, there is a request at 12, please provide a brief production program and explain the type and number of machines to be used for panel production?
Yes.
And the answer is we will use 2 CMS machines to ensure milling of 4 number panels per day, 9 by 2.2, approximate monthly outlook of 60 to 80 panels. Each panel will take approximately 5 to 6 days to complete.
Yes.
And the date of that review is at the top.
Yeah. You want me to read it out?
Well, it's the 17th of July, 2016.
Correct.
Would you look now, please, at page 938? This is in the tender proposals of the 25th of January. Would you go down to the bottom of the page? Sorry, we've gone down too far. Affan will be implementing a new production line in a new facility specifically designed to suit the production of between 8 to 80 panels per month. Now, we know, do we not, that Affan did introduce a new production line in a new facility.
Yes.
And indeed, you've put a picture of that new production.
No, that is the facility at DIP.
That's the facility at DIP?
In my presentation from Friday,
slide
that is
4.
the facility in DIP.
Thank you. So those are the, you say those are the CMS
Correct.
machines.
I've only visited the at DIP.
Did you take any measurements of that facility?
Not of that machine, no.
Do you know anything about the new facility?
No.
Have you seen any pictures of the new facility?
I may have seen architectural drawings of it, but I can't recall to say for certain.
Would you go up page 938? Just a little further. So we're in 938, please. Stop. What is said there in the fourth paragraph down, is at present we envisage approximately 700 panels, 9 by 2 by 2, and due to the calligraphy, each panel is unique. 700 panels, each 9 by 2 by 2, that is 19.8 square meters, comes to 13,860 square meters.
Yes.
So there simply, with 700 panels, wouldn't be anything like enough panels to achieve full coverage.
Yes, and in my report I state that I understand that's a mathematical error.
And you understand that, and it appears on a number of occasions in your report, from Dr. Affan.
I believe it's only stated once about the mathematical error in my report.
A mathematical error is, but there's, as I understand from Dr. Affan, appears several times. I needn't take you to it.
You mean my discussions with Dr. Affan?
Yes.
Yes.
You may know this from your reading of Marina Kinderland's presentation. In her slide 21, it's made clear that the surface area to be panelled is 17,315 square metres. Do you accept that figure?
I do, although there are several documents that have a different square meterage, but yes.
Now, if the 9 by 3 typical module shown for option 1 on your slide 2 was adopted, that would be 27 metres squared per panel.
Okay.
And that gives ample coverage to the 17,315 square metres.
Okay.
700 or at 950. Do you agree that the panels had to be joined top and bottom to the diagrid members?
Well, which members are you talking about? If you're suggesting floor to floor, no. If you're suggesting that they could be fixed to any of the horizontal diagrid members, then yes.
So we're talking, I think, only floor to floor, or floor to midspan and midspan to floor.
Correct.
Those are the two
Yes.
pot arrangements. And it's important that you should please look at RAS 5, which is your exhibit, but it's also reproduced at Ms. Kinderland's slide 13. That is the panelisation process steps.
Can somebody move the mouse out of the way, please, with the text? Or is that for me to do?
That's for you, I think.
You're right?
Yes.
Can you see the first panelisation is preliminary subdivision of facade surface along horizontal diagrid members?
Yes.
Now, those, of course, could be floor to floor, or they could be midspan.
Correct.
In your slide 6, you have drawn lines across what's been known as drawing 003, I think, to show that to show the midspan lines. Is that right?
Correct.
And the point of your slide 6 is to show that one could attach to the midspan lines.
Yes, as it
The
shows on
midspan
the
line.
left-hand side image from the IFC drawings.
Can I put this to you? That would have to be the case if the panelisation adopted was the 2.5 by 4.5 module that we looked at in your slide 2?
No, it was for the contractor to decide the panel sizes, not to follow exactly what was in the IFC.
But if the size chosen was Ms. Kinderland's option 1A, look at her slide 11 again, please. Which is the left-hand option, and those were the sizes, you would be spanning at the midpoint.
In some instances, but not all the way around the building.
Not necessarily all the way around the building, because you could do a mixed option, is your point, is it?
Well, the point is, as is in Ms. Kinderland's report, and the joint statement, is that some instances, because of the curvature of the building, you cannot span a vertical 4.5 metre panel.
Let's look at that, please. In Exhibit 1, in File 18, that's the electronic bundle, File 18. The point I think that you are making is that if you look at the... Can we zoom in on the right-hand side of that exhibit to show the blue and the green dimensions? Further right. The point I think you're making there is that certainly with the blue dimensions, planning from floor to floor, you couldn't do a 4.5 metre panel all the way around. With the green dimensions, and the green dimensions I think were added by you, is that right?
Correct.
The only areas where you could do the 4.5 metre panel would be those areas where the floors were closer together, even at half level.
Yes.
The point you made in your column of the experts' joint minute in line 2 at the end of the second paragraph, this is also in File 18. Would you go up, please, operator, to line 2? And the end of the second paragraph, you say the panel size stated in the Affan's tender return is of similar dimensions to the model sizes noted on IFC, which states that dual sizes to be 2.5 by 4 or 9 by 3, vertical span 4.5 or 9, typical to preferred contractor module. Drawing 906 does suggest a maximum panel height of 22 metres, however 9 is noted as optimal. Details also noted as potential model sizes options dependent on contractor design. 918, 942 and 946 all show vertical details and state panel height typical 4.5. I consider this to mean the IFC contemplated panels being fixed to the diagrid horizontal member midspan between the floors, that is 4.5 vertically. But in fact, I think you'd accept that the 4.5 metre option 1A, was not in the event chosen by Affan.
But that's not what I'm stating there. I'm stating there that panels could be connected at the diagrid member at the 4.5 metre centres of those diagrid members.
And that would have been appropriate and to be expected if Muskinderland's option 1A, the smaller option, had been chosen. But in the I think your last answer accepts that it was not.
Correct.
That means that you're going with option, or they were going with option 1B, which
No.
has optimal by 3 and maximum 22 by 4.
They weren't going with any option provided in the IFC documents. They were going with their preferred module.
Their preferred module involved spanning floor to floor.
No, it didn't. It doesn't state anywhere in their tender proposal that they're going to span floor to floor. You're making an assumption.
I'm inviting you to consider what happened. You haven't seen any drawing, as built or pre-as drawing, with a panelisation that was possible without using option B, have you?
Sorry, can you repeat that again? Sorry.
There are no drawings showing an option 1A, that's the 4.5 metre.
Within the
option.
IFC?
In the IFC, or in terms of the panelisation that was considered by Affan.
The one being 9 metres, sorry, you're referring to?
The 9 metres we know about, but we're coming to explore what it meant.
So I'm still not sure what point you're trying to make.
Well, let's just do a calculation. You accept that the question of which is the correct base is for the court to determine.
Correct.
And I expect you'd agree that as a matter of mathematics, you need 1,500 plus panels, each of 11.25, that's 4.5 times 2.5 metres, to cover the surface of 7,315 square metre. And we know that Ms. Kinderland has worked that out at 1,539 square metres.
Okay.
Your understanding of the 9 by 2.2 in the tender proposals is that that should be taken not as a typical figure, but as a maximum figure.
I don't believe I say that anywhere in my report.
But we'll come to that. What is your view, your opinion, given what you know about what was built and given what you know about the tender proposals?
You mean in terms of the definition of nominal?
Yes.
That it would be, the average size would be 9 by 2.2. It could be a little bit smaller, it could be a little bit bigger.
So would it be fair to suggest to you, and it's your evidence that we want on this, that for the use of the nominal, you could legitimately substitute the word typical?
Correct.
You know the evidence that Mr. Doyle has given in his witness statements, because I expect you've read those.
Correct.
And you know that his evidence was unchallenged, to the effect that one of the reasons for Affan being the preferred contractor was the low number of panels required, and the fact that they were all, well, it's the second reason, is the fact that they were all curved, so they didn't need to be faceted.
Yes.
If you panelled midpoint to floor slab and floor slab to midpoint, it stands to reason that you would need twice the number of panels, give or take a few, and twice the number of brackets.
If you were limiting yourself to that, yes.
And twice the number of brackets would give you a requirement for an added weight of steel
Yes.
And these brackets are not the small type of brackets that we hold up shelves with. They're very substantial brackets, are they not?
Correct.
Perhaps they'd be less substantial for the smaller brackets, but still very substantial. And the added weight of steel would carry with it significant risk that there would have to be added foundation strength.
I'm not a structural engineer, so I can't answer that question.
Did you cause to have carried out any structural calculations as to what would have been the effect of having far more smaller panels?
No. There was no need to. It was considered in the IFC. The IFC design has smaller panels. So by that fact, I'm assuming that it would need more brackets, as indicated, and therefore was taken into account in the design.
It could be, could it not, given that you've agreed that one of the reasons Affan was the preferred contractor was that the panels were fewer in number, that although the IFC allowed for two options, BAM's preference, maybe the employer's preference as well, was for the larger option.
Yes.
And do you accept, looking at Exhibit 1, which we looked at a few moments ago, and I don't suppose I need to ask you to turn up, that your green dimensions are inevitably going to be applicable only to midpoint to floor and floor to midpoint slabs? Panels, sorry.
That's what the dimensions show,
Yeah.
but that doesn't mean that that's restricted to that panel size.
But that was the purpose of your dimensions.
The purpose of my dimensions was to show that by spanning midpoint to floor, or floor to midpoint, as you put it, a panel size would not have to be greater than the nominal size indicated in the tender proposal.
And it's also clear from Exhibit 1 that if you look at the blue dimensions, to span floor to floor, you are going to have numbers of which exceed 9 metres in height.
Correct, but there was no restriction on where they could fix the panels in the specification.
But you would accept that it was plainly desirable to have horizontal lines at top and bottom of the panels, with them fixed at the top and the bottom.
Aesthetically desirable, yes, but again, not specified in the contract documents as a requirement.
But it was possible to achieve, and it was achieved, with an interpretation of option 1B that allowed 9 by 2.2 to mean typical 9 by 2.2.
If you're suggesting that a typical 9 by 2.2 could result in an 18-metre panel, then I disagree.
Sorry, would you repeat that answer, please?
I said if you are suggesting a typical 9 metre by 2.2 metre panel could result in a metre panel, then I disagree.
But doesn't that entirely depend on the nature of the curvature and the number of the panels we're talking about? If there are very few very big panels, and the typical panels are 9 by 2 by 2, isn't that, by definition, compliance with the requirement for typical panels?
No, because going to the nominal, which is stated in the tender proposal, I wouldn't expect the nominal to go, let's say, beyond a range of 10%, either up or down from the panel size that was stated.
Well, we'll come to that. What you would expect is that there would be variable lengths if you were spanning floor to floor.
Correct.
And that is inevitable because the curve at different points of the surface is variable.
Correct.
And given the irregularity of the torus geometry, there will be considerably different sizes.
If you're spanning from floor to floor,
would you go, please, to Marina Glan's slide 50. And then I don't know whether this is possible, but have beside it her supplementary slide 50, or 50A perhaps, is in folder 23, late documents, expert presentations, AESG model study 202-41025. That is a refinement of slide 50, which only broke down the slides into below 9 and then 9 to 14 meters, and then the bigger sizes. Do you see in the breakdown where we've got less than 8, less than 9, which means 8 to 9, less than 10, which means 9 to 10, less than 11 and 12 and 13 and so forth, you will see that 78.1% of the large panels, 78.1% of the panels of less than 11 meters are less than 11 meters. Just
Yes.
adding up those figures.
Yes.
21.9% is greater than 11 meters. None is greater than 22 meters, which was the maximum specified in the IFC drawings.
Correct.
And all, we know, are within the capacity of the CMS machines which were acquired to build. We know that because they were built.
Correct.
And do you accept Ms. Gillan's analysis that from the first post-contract model on the 7th of March, putting aside your reservations of starting from that model, do you accept her analysis that only 10% of the panels increasing that Model 1, 7th of March, to the final approved model, 29th of June?
Yes, and that's what I've said in my reports.
And you've also agreed with Ms. Kinderland that such an increase is minor only.
Correct.
On your slide 17, which you have headed 70% impact, you have worked out that, I think you say 73% of the panels are over 9 meters.
This slide shows that 73% of the panels are either in height, 2.2 meters in width, or both. So you
Sorry,
can
I should
see
have
actually
been
on
more
that
refined
slide.
about my question. You're absolutely right. But if that is a typical size only and not a maximum size, that tells you very little, doesn't it? If that's specified as a typical size.
If you were to take a range from 9 metres by 2.2 metres within a, let's say, 10-inch range, then yes, potentially that percentage would be less.
But you haven't either calculated or displayed your calculation on a plus or minus % basis, nor have you attempted in your report to say typical means plus or minus 10% or any other percentage.
Okay.
Typical could quite easily refer either to the median or the mode rather than the mean.
Correct.
And so could nominal.
Not necessarily.
Well, I think you agreed with me a little while ago that typical and nominal could be taken as interchangeable. If you agree
Yes.
that, then somebody looking at the tender requirements might take the same view.
But the tender proposal always states nominal.
It doesn't always state nominal, but it states nominal often enough to make it absolutely clear that that is what is being presented, does it not?
Correct.
And so your impact slide 17 is directed at the wrong target. It's directed at analysing how many panels exceed the maximum height, as you've put it, the 9-metre height.
Yes, that slide shows panels that exceed a defined dimension.
And that defined, if this were to make any difference, if this were to be persuasive, you'd have to see the 9 metres as a maximum size.
It could be interpreted that way, yes.
And you'd have to see 2 meters as a maximum width.
Correct.
And I think you would probably agree not only that Ms. Kinderlam has got it right to show that over the period 7 March to 29 June, only 10% of panels increased in length, that was offset by others that reduced in length and reduced in width, partially at any rate.
When the analysis is done between those two models, yes.
And you would also accept, looking, and it's still on the screen before us, at Marina Kinderlam's breakdown of the sizes. Perhaps we could move that slide a bit to the left, thank you. That we can do the analysis another time, but that the large slides, the large panels of over 11 meters are a pretty tiny minority.
That's what the slide shows, correct?
And isn't the truth here that your difference with Ms. Kinderlam is not about the figures, it's about the principle that you have worked on the basis that Dr. Affan's panelization proposal in his tender model should be read as indicating a maximum figure of 9 by 2.2, which it does not say.
My analysis is done on the tender proposal, but yes, I agree with you that the slide on the screen at the moment indicates a fixed size.
Furthermore, whether it was true or false that Affan had made a CATIA model as stated in the tender, the panels are laid with horizontal lines at the top and bottom of the floor spans. And we can see that from Exhibit 1.
Sorry, are you implying that the image that is just off the screen shows the panelization?
I'm showing you the dimensions and that the horizontal lines that are shown from left to right, the dark green horizontal lines that span both the 917 image, or what looks like the 917 image, and drawing 003, go from floor to floor.
I don't agree that's what the image on the left-hand side indicates, but it obviously did span from floor to floor because that's what's being built.
Would you look, please, at Ms. Kindeland's slide 20?
It's nearly 1:10.
I just looked at my watch and I see that. Do you want me to ask you this question about slide 20 and then we can move on? That shows the structural analysis of the mock-up of the Future Museum. That shows the panels supported at each end.
Correct.
And that shows on the left-hand side the 9x2x2, and that is an Affan document.
Correct.
And that's taken from the tender proposal. I'll let there.
Can I just clarify something on that? What do you understand supported at each end to mean?
That there is a bracket at the end, each end of the panel, and that's it. It doesn't define where on the building that is to be fixed. It just states there now panel support both end to steel frames, but it does not state what level of the steel frames.
So that of itself doesn't tell you midpoint to floor or floor to floor.
Correct.
My suggestion, though, is that Model 1B fits that drawing, that diagram. Model 1A does not.
It could be interpreted that way, yes.
Okay.
Yes.
Right. Well, in that case, we'll resume at 2:10. Mr. Smith, you know
Yes.
the score. You don't speak to anybody about your evidence while being cross-examined. I will get in touch with the Swiss lawyers and tell them I'm sitting until 5.
That's very helpful.
I think it's
I suspect we may make quite good progress this
okay.
afternoon.
I think it's rather more important that we do make progress.
Well, yes.
Also, you need to get something.
Yeah, if you just let me get my telephones and
Yeah,
then I'll go out for lunch.
That's the hard part.
Thank you very much. from India. But this number is like not from India. India? India not? Okay, okay. What I can do is I can connect you. I can check. I will check my colleague who can talk to you. Do one thing. I take this email. You email, and then you explain. Then you ask the requirement because this you you will speak with somebody from here, the LLC codes, who deal with registration. At least you so that you can. Get registered. First, you need to get registered with the DIFC codes as a lawyer. And there is some requirements. You can ask in your email. You can ask which requirements which is needed for one to be enrolled as a lawyer in DIFC codes. Okay. So, like this one, it will assist you registry.
No, I've been sneezing all yesterday. I think like a hay fever type.
Getting enough from the transcribers, he said the next thing you see.
Sorry, I wondered if the coughing, maybe.
The coughing, you said further back.
Yeah, no problem.
No, I'm not, sorry, it's just because, I know offense to anything, but it's just if you're further away from the mic.
Sure, yeah. No, what's the, yeah.
You would. Alright, so Lord Marshall will say, exactly, Lord Marshall will say, you've got, Mr. Kenny's going to make a presentation. And you go as fast as you can to Alia, who's the registrar. If you fall over, you're fired. Yeah. And you can,
By 15 years ago.
yeah. But you know the song? When you approach the bench in the song.
And this must be something like that.
Yeah.
I don't think it'd be mine.
And if the judge says the floor's lava. What do you mean way too far? That's the only serious thing. In fact, you can make yourself more useful. This one is to be handed to add a form mark. So the one in the file goes to the registrar to give to the judge. The one not in the file goes to the registrar to give to Mike. Mike's the chap sitting behind you. Everything hangs on. Yeah, this is everything. I hope the transcript reads it.
Did you manage to get some food, Austin?
Yes, thank you.
Good.
sans faute de poisson.
Good afternoon, Mr. Smith. I'd like you now, please, to look at your slide 8. Now that's headed killer model. I take it that merely reflects an understanding that you obtained from your instructions.
No, if you look at the model, at the file name, it has the letters KLD, which indicates that the model has been supplied by Killer Design.
I take it that you hadn't seen it before the week before the hearing.
Correct.
And one thing that it shows, you've got a quote from our old friend, the contractor claims notice 222 at the bottom. But what it does show is that this panelization gives you the smooth surface of
yes.
double curvature. And again, I take it that the note issued to Affan on the 2nd March 2017, 10:27 a.m. Was relying on instructions that you had.
That is from the Aconex transmittal.
Of that document?
Yes.
Yes. Would you look, please, at your slide 9? And that is, it says overlaid with RAS 15. What do you mean by overlaid there?
So what I've done with that image is I've taken my exhibit 15, which is the one of the elevational drawings from Killer Design, and overlaid the image screenshot from the model that was supplied, and added a transparency to that image so that the underlying elevation can be seen through it. And the purpose of that slide was to show that the horizontal joints line up with the floor levels that are indicated on the elevational drawing.
And that overlay was performed by you?
Correct.
And that was the overlay of your RAS 15?
Yes.
At your slide 14, you've got these drawings here, which are drawings that came from the panelization workshops.
Yes.
And the right-hand drawing first says check all horizontal soffits that are at floor level. They're not at the moment. And then somebody has drawn the rough dimensions vertically between the floor slabs.
Yes.
And this is an instruction, or this is a suggestion to check that the horizontal joints are at the floor levels.
I assume that's the, yes.
That's its intention. And that's not just an aesthetic matter, is it?
Well, yes. It could, the joints could have been below the actual floor level within the spandrel of the panels.
Well, is it, having regard to Marina Kinderland's slide 20, which we looked at, and the way that the panels are intended to be joined to the diagrid members at top and bottom, that only works, doesn't it, if the joints are at the floor levels, or if you were right about the midpoint spans, the midpoint spans. Doesn't work if it's just halfway through.
That would depend where the brackets are on the panel, but going back to the image that you showed me before the break, where it showed the connections at the end of the panels, then yes.
And we established before the break that that slide 20 came from the tender proposals.
So can you show me slide? Yes.
And I think the evidence you're giving to us on now is that that plainly shows that the link-up needs to be where the diagrid is.
Correct.
The note I was just putting to you is not a note that is just for aesthetic concerns. It's a note for a structural and sensible, practical way of dealing with it.
Based on where the support is shown on that slide, yes.
And the left-hand slide has this, only as an option, which of course leaves it
Can we
open.
go back to that slide, please?
Oh, I'm sorry, it's 14. Your slide 14.
Yep.
Only as an option, check if continuing the orange peel segments. Did you work out what the orange peel segments were?
Yes, it's the top, the roof section.
The roof section.
Yeah.
Are more pleasing. Also check if there are technical issues with the waterproofing and strength of triangular panels for this option. If so, retain existing roof panels. Can you read those last two words? Show both.
The both option that Mr. Killer wanted to see both options side by side.
So there are different concerns there. One is continuing the orange peel segments, and that is a more pleasing, which I take it as aesthetic.
Mm-hmm.
And then also he's concerned with technical issues of waterproofing, panel strength, and so forth.
Correct.
So
That's
that's
what it
certainly
appears
not
to be
just aesthetic.
stating, yes. Sorry?
That's certainly not just aesthetic.
Correct.
I want to ask you this as a general point. First of all, isn't this kind of discussion, whether dealt with by way of jotted note or conversation or emails or however, isn't this just the sort of discussion you would expect between a subcontractor with design responsibility who also has specific responsibility to develop the design with the employer's design team, to engage in with the architect.
Not to engage with the aesthetics, no.
Why do you say that aesthetics are excluded from the realm of design?
Because the tender specification provided a detailed design which, without the contractor having to do any of his own technical design, should have been sufficient to build from.
Well, I'm sorry, is that right, Mr. Smith?
Yes, that is the standard practice.
I think you have said in your reports and agreed, and it's an established matter of fact, that the panelisation is effectively to the contractor design.
Correct. And this is not the contractor's design by the looks of it.
If the contractor, I'm asking you a general point here, if the contractor comes up with a design that the architect thinks at the extreme is just aesthetically not acceptable, and the design is subject to employer approval, is the architect not entitled to say, no, that's not good enough, let's see if we can think of something better?
The architect could have, if he wanted to, put restrictions in the specification on the design that the subcontractor would perform in terms of aesthetic requirements. Going to your point about the client approval gives the impression that the contractor was not allowed to design his own panelisation scheme if he had to seek approval from the client for whatever he produced.
But you've used the word design there in the context of acceptable aesthetics as well.
Yes.
And all I'm putting to you is that isn't it in this type of contract, which isn't after all uncommon, that there's design responsibility on the contractor or subcontractor, as the case may be.
Not from an aesthetic point of view.
With a responsibility to discuss it with the design team in the sense of the architect and the engineers. And they all have a responsibility to come up with a solution that deals with aesthetic and structural concerns.
The aesthetic requirements, if there were any restrictions, as I said before, should have been clearly stated in the specification, and they were not.
Well, how then do we interpret these notes, which deal in both drawings, because the right-hand drawing also has some aesthetic design issues about smoother transition, about some strictly structural issues about joints at floor level. The left-hand drawing has check orange peel segments and pleasing, and technical issues about damp proofing and strength of panels. These are completely hybrid in terms of design responsibility, aren't they?
No, you can split them out between aesthetics and technical requirements.
And is it your evidence to this court that that is a requirement of design responsibility where discussion with employers' representatives and approval by employers' representatives is built into the process?
From a technical point of view, ensuring that it can actually be built, yes.
And I'm suggesting to you that that split is unrealistic and goes beyond the plain meaning of the word design.
No, because the smooth transitions are not a technical requirement.
Well, we'll leave it there. Clause 2.6 of the tender specification. Would you go to divider 10, your report, in the electronic file, page 8, 3.2.7.
Sorry to intervene, sir. Could you please repeat the reference again? if it is for terrace?
The reference is Electronic Divider 10, page 8, paragraph 3.2.7. Which quotes clause 2.6.
Is this the file, sir?
That's the one, yes. Thank you. Clause 2.6 sets out the... We've lost it. Can we go up a little bit? That's it. Sets out the design and performance requirements. Subclause A states, design responsibility determines sizes and thickness of units and the type, size, number and spacing of fixings. Determining the sizes of the units is absolutely essentially a hybrid matter of aesthetic preference and structural integrity. Is it not?
No. I don't read it that way.
Well, what is it?
Well, the panels could have been any size as long as they were able to be fixed at the horizontal die grid members.
And no matter if they're higgledy-piggledy and some end at the midpoint and some end at the top?
If the architect wanted it to be done in a particular way, it should have been specified in the tender documents. It was not.
And you don't think that's a little artificial?
No, it's standard practice. If you want to place restrictions on the aesthetic design, you need to state it in the specifications. If they wanted the joints to be at the floor level, it should have been stated in the specifications. It is not.
Let's go on, please. I want to come to the hexagons. Slide 18, please. Your slide 18. What Colte write is, regardless of the textured pattern on the stainless steel cladding sheet, we're concerned at the visual impact of the rivets. More than the rivet itself, the concern is on the slight sinking of the sheet around the rivet. The samples produced should include the rivets to evaluate aesthetical impact. And the response from Affan is, this will be part of our mock-up for review. If you were right in the evidence you've just given to the court, the fact that there were rivets which caused the sinking of the sheet around the rivet would be a matter that was aesthetic only, because it would be structurally okay.
Yes, and as you can see on the image on the left, a mock-up was built showing the stainless steel sheets fixed to the panels using rivets, and as far as I'm aware, there was no comments made at the time of that mock-up. There's also nothing in the specification that precludes the use of rivets. If they didn't want to see any fixings on the outside, I would have expected the specification to state, as I stated in my report, no visible fixings, or the sheets to be fixed with secret fixings.
But if the rivets are part of the tender, and there is a tender inquiry saying, look, we don't want to see any rivets because they may be, because there is a slight sinking where the rivet head.
It doesn't say they don't want to see it. They said the aesthetic impact will have to be evaluated.
Yeah.
Well, there's no documentation after this mock-up that states that it was an issue.
You don't think, Mr. Smith, you're splitting hairs here?
No.
The aesthetic impact, which is being the cause of concern, is that there is an indentation around the rivets which is visible.
Exactly. That's an aesthetic issue, not a technical issue.
But it's an issue which falls within design. Otherwise, the contractor wouldn't be saying
not the contractor's
it's part
design,
of our
no.
mock-up for review.
Sorry, I spoke over you. Can you repeat your question?
What I'm saying is that if that wasn't treated as part of the design, the contractor wouldn't be responding to this inquiry. This will be part of our mock-up for review.
Yeah, and as I've just stated before, the mock-up was produced showing the rivets, and there was no, that I've seen, no documentation after the mock-up was produced that raised the issue of the rivets being visible.
We know, in fact, they didn't go ahead with rivets.
Excuse me?
We know, in fact, they didn't go ahead with rivets.
Yes, and why that didn't happen, I can't speak to, because I haven't seen any documentation.
Go to slide 19, please. This is a quote from CCN-222. Design team were unhappy with how their design panelization looked and subsequently instructed incorporating hexagonal patterns in the stainless steel to overcome the resistance of the sheet thickness. Comment received included the rejection of vertical hairline joints and instructed full-width panels, length of stainless steel. Can we just look at the diagram above it? The hexagons, to deal with an old chestnut, don't join at the corners, do they?
Sorry, they've gone up one slide rather than staying on the...
Oh, okay. I see the hexagon pattern.
Yes.
Okay. You can see the hexagons don't join at the corners.
Correct.
So it's not lots of separate hexagons. It's
Correct.
one sheet.
Correct.
With incisions made in the sheet.
Yes, so just sorry, as a point of clarification that I, if I may,
Please.
heard during the course there's been the word scoring used, which implies that it's only cut partially into the stainless steel sheets. So the hexagon pattern, as you've stated, is an incision that goes all the way through the sheet, and they are individual cuts, shall we say, that do not join up but form the hexagon pattern.
Let's put it this way. We are agreed that the hexagons are created by incisions through the stainless steel sheet.
Correct.
They go all the way through.
Yes.
They're created by laser.
Correct.
But they don't join at the corners.
Correct, yes, they're not individually cut.
So if I'm feeling particularly tough and I hold up a sheet, 600 mil sheet of this steel, it's not very thick, so possibly it's not so difficult. It won't fall apart.
Correct.
It's one sheet with a lot of hexagons cut into it.
Yes.
And the purpose, if you look at CCN 222, is to overcome the resistance of the sheet thickness.
Of its, the ability to bend the sheet, yes.
Ability to bend the sheet, thank you. Otherwise, often called in this case, drapability.
Yes.
Drapability may be important aesthetically because it's not very nice if it doesn't drape over the panel, but it's also structural because you've got to be able to have the sheet following exactly the surface of the panel.
The word structural I'll disagree with, but your point I do agree with, that it's needed to, the sheet is required to follow the curvature of the composite panel behind it.
And can you explain to His Honour, because I am personally unable to follow it, why is that not structural?
Because the stainless steel sheet isn't providing any structural requirements. It's just the cladding that is fixed onto the composite panel.
Well, it's not support, but if it's not draped and securely fixed, then there's always a risk that it'll fall off.
But that isn't
Yeah, but it's not a structural issue.
I can follow that.
Sorry?
I can follow it.
Yeah, yes, I understand that. Okay. But it's not purely an aesthetic issue, is it? So I may be using structural far too widely because I'm not talking about structural
I think
support.
you are.
Yes, I'm perfectly happy with that criticism. I'm not happy with the criticism that if it's not structural, then it is aesthetic, because this isn't for aesthetics, this is for...
No, I'm
philosophical
agreeing with you.
buildability.
On that point, I'm agreeing with you that the hexagons were employed to improve the ability of the sheet to match the curvature of the composite panels.
As to the studs that were eventually used, I think you accept that they were used on 1 and 3 hexagons rather than every hexagon.
That's what the drawings indicate, yes.
And the final point is this. Would you look, please, at slide 20? And we see there the steel sheeting on the underside of the canopy.
Yes?
And there are no hexagons.
Correct.
So if the hexagons were purely for aesthetic reasons, there'd be no reason to put them on the underside of the panel.
So the image that I put up here was to show the hairline, the straight hairline joint.
Yes.
And the comparison that I was making was between the stainless steel sheets that are fitted to the composite panel, you have what has been termed the zigzag pattern, so that it appears that each panel is clad with a single sheet of stainless steel rather than a number of sheets of stainless steel. And my point was that if the sheets had a straight hairline joint, you would not be able to see it.
Now, we've had a lot of unusual words in this, in the context of a construction case anyway, in this case. And one of them is beautification. The suggestion is that the hexagons were there for the beautification. They're not here. If they're effective at beautifying the steel panels, there'd be no reason not to put them here, wouldn't there?
The point I believe that the design team had an issue with, as I just said, is that each sheet of stainless steel, if it had a hairline joint, it might be visible and indicate more than one stainless steel sheet fixed to the composite panel. What I understand the design team wanted to have in having the zigzag pattern was to achieve the look that the composite panel was only clad with one sheet of stainless steel.
I understand that. Now, this canopy is close enough for every visitor who goes to the Museum of the Future to be able to see this steel sheeting at close quarters.
Correct.
And rather closer quarters than he or she would normally see the surface of the torus.
Yes.
So my only point is this, and it's a relatively simple one. If the hexagons were there for beautification only, there would be no reason not to beautify the canopy in the same way.
No. I'm not sure if I'm not explaining my point.
No, you're explaining it very well. You think the beautification part of it, leaving aside the drapability part, you think, or you say, that the beautification, as you infer it, came from not seeing the hairline joints because the panels with the hexagons in interlocked across the big panels, so you didn't notice the hairline joints.
Correct, which is what it states in the quote at the bottom of the picture.
Why wouldn't you do that here?
On the canopy,
Yes.
Because you don't have the 6WL pattern that you do on the stainless steel that's clad to the composite. So there's no pattern to disguise. If you didn't have the zigzag pattern on the composite panels and you didn't align the 6WL, then it would be even more obvious that the composite panels were clad with more than one sheet of stainless steel.
Now, I haven't followed that.
Okay. The stainless steel sheets that are on the composite panels have a pattern embossed into the steel. The sheets on the canopy do not. The design team wanted the zigzag pattern to get rid of the hairline joint, but also across each sheet and across each panel to align the 6WL pattern so that you could not see a break in that pattern, either across one panel or between panels.
But they wanted to get rid of hairline joints as well, and they haven't bothered.
Well, they have. That was the effect of having the zigzag pattern.
Yeah, but they haven't on this canopy.
Yes, because there's no pattern on that steelwork.
I have no further questions.
Mr. Smith, you were taken to the tender proposal. If we can go, please, to the combined bundle at 915. Sorry, if you could start, please, at 861. I'm so sorry. So this is the commercial proposal. You aware there was a technical proposal as well?
Yes.
So we've got 862. In the commercial proposal, at item 1.1.1, it refers to facade panels, nominal size 9,000 by 2,200. And that word nominal was emphasised to you, and I'll ask you some questions with response to that. This is the only place in the proposal where the word nominal appears as far as I can see. If we then go to 915, which is a technical proposal, and then we go within that to 917. And below, please. Scroll down, please. Pause. It says the panels and main facade are proposed to be 9 metre by 2.2 metre in size. Do you see that?
Yes.
We go to 918. And again, this is something you were taken to, and it refers to panel length 9,000 millimetres, panel width 2.2 millimetres.
Yes.
And then we go to page 938. And this is section 2.4.2, and it says at present we envisage approximately 700 panels. You talked about the number being an error. 9 metre by 2.2 metre.
Yep.
So these are the three references in the technical proposal. Which of the technical or commercial proposal would you see as more relevant to deciding the modules or panel size chosen by the contractor?
From a technical point of view, the technical proposal.
Thank you. You were then asked, to the extent it's relevant, your understanding of the meaning of nominal, and you said little bit smaller or little bit bigger. Can you just elaborate on that, please?
Well, I think I also said potentially a 10% range either above or below those dimensions.
Right. Why, in your experience, why would anyone mention the word nominal?
I guess for that exact reason that I've just explained, that the panels may not have been exactly that size. They may have been 10% smaller or 10% larger.
Right. You were then taken to a document which is referred to as slide 50A of Ms. Kinderland's presentation. So I believe, operator, it's file 23, and then, yeah, that's it, the ESG model study. Bear in mind what you just said. What Ms. Kinderland says is that, and I've done the arithmetic, that 50.3% of the panels were greater than 10 meters in the initial, what she calls the initial model, and 57.6% of the as-built model was the panels were about greater than 10 meters. So bearing that in mind, that in each case, what she calls the initial model and the as-built model, more than 50% of the panels were greater than 10 meters. How does that relate to your understanding of 9 by 2.2 nominal?
Based on my 10% assumption, that would be the figures that you've just provided to me would be greater than that.
Thank you. You stated in your cross-examination nothing in the there's nothing in the specification.
I hesitate to interrupt, but I'm just concerned about the last question, because in the Friends arithmetic, I think, may be wrong. The greater than 10 meters is 10.7 plus 4.1 plus 5.4 plus 2.9 plus 8.4. I think he's included the earlier figure of less than 10 meters.
No. I might have. I understand that that's greater than 10 meters.
Greater than 10 meters includes less than 11, less than 12, less than 13, 14, 14 and above.
Well, you can make submissions. Sorry, Your Honour, are you happy for me to proceed?
Yes, please.
You said in your answer to one question that there's nothing in the spec that requires the panel spanning floor to floor. What did you mean by that?
Exactly what it says. There's the specification provided no restrictions on the facade contractor in terms of the panel size or where the panels could be fixed to. And I think that is one reason for that might be that within the specification there was also the option for a rain screen cladding, which may potentially have required to be fixed elsewhere to the diagrid.
Thank you. You were asked a series of questions about aesthetics, and it was put to you, why do you say that aesthetics are excluded from the realm of the design? Can I, in relation to that proposition, can we please look at the document CCN Treble 2? You should have in front of you a file headed Claimant's Disclosure 21st of October.
I have a folder with CCN 222.
Yes, that's it. Your Honour, it's, that's it, thank you. It's tab 2 of the disclosure file.
Yeah.
Mr. Smith, please help me by going within that. It's kind of page 6 from the start, and it starts, it's got internal page 1 on it.
Yes.
This is BAM's submission to Bureau Happold. You've quoted from it in your presentation. At the penultimate paragraph on the first page, BAM says, the contractor has no authority or obligation for the aesthetic design, nor any enhancements or changes to the aesthetic designs, which is provided by the employer in the contract IFC documents, and which must be maintained. And then similarly, although there are other items here, if we go to internally paginated page 28, you'll see a paragraph 3.6, sorry, operators, page 34 of the PDF. You see a paragraph 3.6.18?
I do.
BAM says, in summary, the above provisions of the specification outline the intent of the contract documents and the contractor's, in inverted commas, design obligations therewith. Drawings and information in the specification are intended to show the general form and arrangement of the facade. The contractor shall complete the engineering of the design through the incorporation of the specialist subcontractor's technical details, whilst maintaining the visual aesthetics of their design provided by the employer. The contractor is therefore not responsible for the aesthetic design, nor any enhancements or changes to the aesthetic design, which must be maintained as supplied by the employer. bearing that in mind, can you just help me with why you say, as you were asked, that aesthetics are excluded from the realm of Affan's design?
Because there was no, the design obligation on Affan was a purely technical design obligation from my perspective, which was to ensure the technical requirements of the specification were met in relationship to what was set out in the specification.
In your experience, an architect, what, if any, steps could an architect take if it wished for the contractor or the specialist subcontractor to be responsible for the aesthetic of the design?
I can't really think of any reason why an architect would give a contractor carte blanche on the aesthetic design of a building.
Okay. Then moving on to the questions you were asked about hexagonalization, if we can stay in this same document and go please to page, internal page 76. It's item 8.5. Are you there?
Yes, sorry.
So you gave evidence to the effect, you said something along the lines of the stainless steel sheet is not providing any structural function. And if we look at 8.5.1, this is how BAM describes the series of events. It says the design team, capital D, capital T, were unhappy with how their design panelization in inverted commas looked in the visual mock-up 5 Rev 0 presentation, and subsequently instructed incorporating hexagonal patterns in the stainless steel to overcome the resistance of the sheet thickness. As a specified 0.8mm grade 3166WL to being double curved to the upgraded geometries of the project's panels. Comments received back on VMU 05 Rev 0 included the rejection of vertical hairline joints in all locations and instructed that full width panel lengths of stainless steel, more extensively curved, be used instead to reduce the number of vertical hairline joints. What, if any, structural function did the instruction to use full width panel lengths of stainless steel serve?
None.
What do you understand was the purpose of that instruction?
To remove the vertical hairline joints.
Thank you. Nothing further from you, Mr. Smith.
Thank you. Mr. Smith, when you were out this morning, I indicated that when we've had our view tomorrow, I am going to have you and Ms. Kinderland before me in witness conferencing.
Okay.
But I've got a question now that I'm sure Ms. Kinderland will also want to take notice of, and we'll perhaps discuss tomorrow in more detail, but I'd just like your help while you're here on two matters. The first one is in the tender itself. It's not something we've looked at hitherto, but could we please go to page 923 in the combined bundle? So that is, thank you. Could you just shrink it slightly so that we could see the whole page? Thank you very much, operator. We've lost the text at the top. Yes, okay. So the text at the top says, due to the limitations imposed by the main slabs, all connections of our unitized panels will be to the should be diagrid structure via welded brackets.
Yes.
Okay. Where do those brackets, if you're able to say so, sit in relation to the floor slab?
Those brackets appear, from just looking at the image in front of me, to be connected to what I'm going to refer to as the vertical members on the diagrid.
Yes.
It would be below the floor slab.
And do those vertical members extend between floor slabs?
Yes, well, they extend between the horizontal diagrid members, so they extend vertically at 4.5 metre centres generally.
So let's see if we can find a drawing that can illustrate where the vertical members are, so that
Your Honour, if you go to my presentation
Yes.
and slide 7.
Could we have slide 7 up, please, operator?
So and if we blow up the, well, either the left or right hand side image would assist, Your Honour.
Let's blow up the left-hand side.
Can you scroll
Sorry,
across,
I meant
please?
my left-hand side. Thank you very much. Could you indicate then where the vertical members are?
So when I say vertical, they aren't literally vertical. They are diagonal. So they are the diagonal members that are, you can see, spanning between the horizontals. So for example, Your Honour, if you can see where it says level 3, where there is a floor slab, you then have diagonal members which are spanning up to a horizontal diagrid member which is labelled as level 3 mes.
Yes, I see that.
So those are the members we're referring to.
So in other words, the brackets are fixed to the diagonal members, but not the horizontal members.
That's what the previous image appears to show, Your Honour, yes.
Yes, which means that they could. Does that mean that those brackets could be fixed at any point between the two floor slabs?
That's a structural question I wouldn't be able to answer.
Okay, well let's. Okay, well.
Sorry.
Anyway, I'm having some difficulty with understanding where those brackets might go. We'll perhaps reinvestigate it tomorrow.
Okay.
It's something you might want to look at if you can. The other question arises. Let me find the. Arises from the notes of the architect at the meeting on the 13th of March 2017. That's page 1171 in the combined bundle. Okay, could we just blow up the top of that? I'm interested in note number 1, please. Thank you very much, that's great. So note number 1 says, regarding the horizontal joint lines, I do not know why they are not following the floor levels. So that rather indicates to me that at that point in the design development, in fact, the panels were not jointed or were not intended to be jointed and therefore fixed at slab level. Is that your understanding?
So, Your Honour, this comment from Mr. Killer, from my perspective, is a bit confusing. But again, I can't remember the slide. There is an image in my presentation.
Well, is it the preceding page of this? If you can just go to the preceding page. So in the preceding page, not the next page. Thank you very much. The one before it. Yes, thank you. Is that the one you're thinking of?
No. So,
Okay.
sorry. What I'm trying to explain is the diagrid horizontal members at floor level are not actually at floor level. They sit below the slab level.
Okay, maybe what's helpful is if we go to, where is it? If we go to Ms. Kinderland's Exhibit 1, that I think is the largest scale drawing that we have. Okay, could we blow up the Yeah, that's great. Thank you very much. That's perfect. Thank you. Does that illustrate what you're saying?
Yes, in a way. If you were to zoom in a little bit closer, I'm not entirely sure that this drawing reflects the detailed drawings in the IFC, because this drawing appears to be showing the nodes, the horizontal members aligned with the, actually they're aligned with the truss supporting the floor slab.
Sorry, you'll have to...
So they are, the horizontal members appear to be sitting below the concrete floor slab. So they're aligned, so below the floor slabs, Your Honour, there is a truss which supports them, which is connected to the diagrid as well. And it appears that the horizontal members of the diagrid are aligned with the top steel member of that truss.
Okay, will you try and dig out? I think we've got some sections, haven't we?
Yes, there's one in my presentation.
Well, can we dig that out for tomorrow,
sure,
so that we can look at that rather than take time?
Okay, no problem.
Now, okay. Well, before I let Mr. Smith go, is there anything that either council would like to ask arising out of my questions? Lord Marks? No?
Oh, no.
No. Thank you very much indeed. Okay, well, we'll probably resume tomorrow morning. I think we're likely to get through the quantum evidence quite quickly. So it should be mid-morning tomorrow.
Okay. Thank you.
Thank you very much.
Or I'll call Mr. Kenyon.
Thank you.
I swear by what I believe to tell the truth and nothing but the truth. Thank you.
Mr. Kenyon, I'd like you to look, please, at your reports. Your first report is in the electronic bundle divider 11 and is dated the 24th of May this year.
Yes.
Would you look, please, at page 170?
Sorry, I've lost the display's gone. Sorry, I just tilted it, it disappeared.
It's locked him out of the
Sorry.
system.
Is that your signature?
It is, yes.
And does that report contain appendices and exhibits which are also in divider 11?
It does, yes.
Would you look at your second report, divider 15? Is that dated the 5th of July 24?
Yes.
Does it also contain appendices and exhibit?
It does.
And would you look, please, at page 77? Is that the signature page?
It is, yes.
And is that your signature? Yes?
Yes.
Would you look, please, at your third report in divider 17? Is that dated the 31st of July?
Yes.
And does that contain appendices?
It does, yes.
And is the signature page, page 143?
Yes.
And your fourth report, divider 21? Does that contain, is that the fourth report, 1st of October 24?
It is, yes.
Does that contain one appendix, which is your review of the late documents relating to labour?
It does, yes.
Could you look at page 38?
Yes.
Have you compiled 2 experts' joint minutes with Mr. Atherton?
Yes.
Is the first one at divider 19, dated the 2nd of September?
Yes.
Have you both signed that at page 41, which is 42 of the PDF?
Yes, correct.
And the second one, divider 22? And that has appendices. Is that dated the 17th of October 24?
It is, yes.
And is the signature page 22?
It is, yes.
And do the views that are recorded as your views, rather than Mr. Atherton and those joint statements, and the views expressed in your report, represent your honestly held beliefs and opinions?
They do, yes.
And where you've stated facts, do they represent your understanding of the facts?
They do, yes.
Yes, would you wait there, Mr. Kenyon? You're going to give a presentation, are you not?
I am, yes.
So perhaps you could start with your presentation.
Okay, thank you.
Now, the presentation is in.
I've got the hard copy.
You've got a hard copy. For others in court, it's in the late documents experts presentations file of the electronic bundle.
Okay, good afternoon. The presentation I've prepared is a consolidation of the issues and differences between Mr. Atherton and I. Mr. Atherton and I have reached a broad measure of agreement across quite a number of the issues, and the purpose of these slides is really to provide, as I say, a consolidation and a reference of those differences. It's not my intention to go into detail on each and every of the slides, but I will go into detail to explain why it is and where it is we are different. I have received an addendum report from Mr. Atherton yesterday afternoon. I've not had the opportunity to update my slides to represent where there is now a narrowing of difference between us. But I will talk to some of those differences that have been reduced as I progress through my slides. There are a number of important issues in relation to the issues that I'm looking at, and they are essentially as follows. The first issue is a breakdown to the subcontract price. The second issue is pricing discrepancies. 3 is the applicability of the subcontract payment schedule as a basis for valuing the works. And then I deal with the differences between the experts in relation to BAM's claims, the expert's valuation of D1 as built, and also the differences between the experts in relation to D1's valuation of the as built. So if I could start at slide number 4, please. 5, sorry. There are 4 sources of cost and price information that I've come across in relation to this project, and these are those listed on slide number 5. If we go to slide number 6, please. This is the pricing document that was exhibited, or the price that was exhibited by D1 in support of its claim against BAM. And you can see in column C there is a breakdown to the 125 million. In the reply to the defence to counterclaim, at paragraph 6.9, D1 provided an exhibit 032, and that exhibit was referenced as being the source of a correction to the contract price in column C, where the workshop labour was stated to be needed to be revised from the 6526425 to 25 to 30 million. So when those factors are included into the calculation in column C, they modify the contract price to 146 million and 152 million. And that is a difference of between 17 and 22% of the tendered and accepted contract price. If we could move on please to slide number 6.
You mean 7?
We'll just stay actually on 6 for one moment actually. We do not have a breakdown in detail to the price of 125 million that explains how the quantities have been arrived at.
Well, that was a negotiated figure, wasn't it? I mean, they came in at 135, and then it was chopped down to 125.
It has, and if you look at, by way of example, if you do look at the tender return calculation, which I'll refer to in a minute, that had an allowance for overheads and profit of, I think it was 25%, whereas it was dropped to 16.9%. But the reason why I'm addressing these points is that there are some issues that I've found with the tender, and that if we're going to look at evaluation of change on an add and omit basis, that does become an issue as to the sufficiency of the tender that would need to be accounted for before one jettisoned totally the contract price and how the contract price was built up. So my reason for running through these points is really to bring that point forward, and indeed that point was raised by D1 at paragraph 6.9 to apply to the defence and counterclaim. If we please move on to slide number 7. There are notable discrepancies between the two pricing documents that don't necessarily, in my opinion, account for the difference in the commercial agreement that will reach between the parties to arrive at the 125 million. And there are discrepancies between some key quantities. So if we look at the tender return calculation, the 3rd of September 2016 document, the stainless steel quantity is 27,444 square metres, whereas the as-built scheme is 24,643.73. And it's been one of the contentions raised in this matter that there has been increased wastage of stainless steel sheeting due to the variations that are claimed by D1. But it can be seen between C and E columns, there isn't an increase. In fact, there is a decrease in the stainless steel quantities. Now, in column C, the 3rd of September 2016 figures, they are derived from a scheme which sets out a panel size of 9 metres by 2.2 metres. So these these factors or these quantities, the 12.12748 and the 27,444, are consistent with, on that pricing document, with the scheme of panel sizes that is 9 metres by 2.2. If we move to the summary pricing document dated the 17th of October 2018, this does it, which we looked at on the previous slide. This seems to be a presentation of the contract price that was developed sometime after the contract was awarded, and it attends to a variation on one of the one of the lower lines, on line item 24, of a D-scope of the GRP reveals. That was a change that was introduced post-contract award. So it does seem to me that the 17th of October presentation is a presentation of the contract price that was derived sometime after the GRP de-scoping. Now, one thing that is interesting with the 17th of October pricing document is that it is based on a panel size of 4 metres by 2 metres. If we could move on, please, to slide number 8. This is an extract from the BOQ. Build-ups to the BOQ rates and prices have not been provided. Ordinarily, if we were looking at a variation valuation on an add and omit basis, or even to try and develop new rates and prices, we would look to use the existing rates wherever possible, and particularly as these are blended composite rates, we would look at those rates and extract out of those rates areas that are different. So for instance, if we now had a change in the quantity of stainless steel due to increased wastage, we could adopt the stainless steel price and adjust the percentage of waste accordingly. And we could follow through with those changes for foam, fixings, and additional machine time if it was decided that the hexagonalisation was a variation. We haven't had that breakdown, so we've not been able to look to prepare a valuation on that basis. If we could move to slide number 9, please. This is the subcontract payment schedule, and this was used to value progress payments up until the point that BAM took over Affan's works, or D1's works. Payment schedules are for payment purposes typically. The extent to which these represent a true value of the works is something that, in my opinion, needs to be looked at. If we look at the amount for design, this is 31,250,000. If this is going to be used as a figure to add to other items to provide a valuation, then care needs to be taken to ensure that the 31,250 million does not include and or overlap in any way with the amounts in the balance of the valuation. Now, if we look at the pricing document that was produced as a basis for valuing the difference in D1's original claim, the one that I referred to at the beginning where we substituted the 6.5 million with the 25 and 30 million, the design allowance presented in that document is 13.3 million. If we then look at the document that was exhibited at D032, which is referred to at paragraph 6.9 of the reply to the defence to counterclaim, the design allowance is 3.7 million. In my opinion, that variance between those two figures and the 31,250 million requires some degree of investigation. Contractors will often seek to undertake work and be paid for work on as positive a cash flow basis as possible. And because of that, payments are on payment schedules can often be very favourable. Now, if Affan's design allowance was 13.3 million and we have a payment to be paid of 31 million, then it seems to me that D1 would also be recovering compensation for other works. And D1's other works, in addition to design, will be fabrication, purchase of materials, and setting up the facilities to deliver the fabrication of materials for this project. If that 31,250,000 includes for those works or a contribution to those works, then it would be incorrect to add that sum to the as-built cost of fabrication, materials, and the setting up of facilities.
As you say, it's a double recovery.
It would be a double recovery, yes. If we could move on to slide number 10, please. If we could then, this section now really will run through the claims that BAM have against D1. If we could move to slide number 11, please. I'm going to skip through this section reasonably quickly because the detail of the difference where there is a difference is set out on the slides that follow, and it's probably not going to assist anybody if I just go through those verbatim. There are two areas of difference that I'd like to discuss first. There's a difference at item 3 between Mr. Atherton and I relating to the valuation of production costs. We've agreed the overall envelope of production costs in the sum of 173,658,462.53. Mr. Atherton provides a second valuation, and this second valuation only accounts for what are called procurement payment requests. Procurement payment requests were a document issued, I understand, by D1 requesting that BAM paid for certain procurement items. The PPRs ran, so far as I can tell, up until the point that BAM took over D1's work. So consequently, to only consider the PPR costs would not account for the entire costs that Mr. Atherton and I have agreed on. There's a difference between Mr. Atherton and I in relation to items 5A and 5B. Items 5A and 5B are the subject of the Memorandum of Agreement. If we could please move forward to slide number 14, please. It's Mr. Atherton's position that he's not able to reconcile the amount in the MOA with the supporting backup provided in the MOA. Now, bearing in mind that the MOA is signed and agreed by the parties, the figure in the MOA for the glazing washing machine and the cutting machine is €1,103,884. I have gone through the documents and I can get the documents to balance to the sum of 1103,413.56. I have not carried forward that sum because there is actually a credit for attestation fees that was not considered in the amount agreed in the MOA, so I have removed that figure. And I carry forward in my valuation the AED equivalent of €1,103,413.56. Whilst there isn't an invoice for the water jet cutting machine, bearing in mind it has been agreed in the sum of 1,103,884 with other items, there are, however, payment transfers from the bank to the suppliers that do reference and correlate with those amounts. The other areas of difference, very briefly, are in relation to the costs incurred after the 31st of October. It is a relatively small amount, and this is on slide, and this is on slide number 15, the difference here, and it is that Mr. Atherton values a slightly larger amount than I, is due to sample size differences, where he values some items in his sample that I don't value in my sample. Where we have a common sample, there is a difference in how we deal with some small value items from Dabas, who are the electrical supplier providing the LED lighting. But as I say, overall, the difference is relatively minor. If we could move on now briefly to the subcontract variations, and that is on page number 16, slide number 16. The difference between Mr. Atherton and I relates to the emission of the sand-blasted etching to glazing. I don't believe that this is a variation that's in dispute between the parties. I think Mr. Haslam acknowledged this as being a variation in, I think it's a letter in May 2018, I think, I can't remember quite the exact date. And he's mentioned in that letter to providing details in support of the valuation of variations. I've not seen what those details are, and I've not seen a detailed build-up from D1 to support what that emission may be. However, in the contract price breakdown that was produced after contract award, dated 17th of October 2018, there is a reference to D1 acknowledging a valuation emission of 500,000 AED, but I've not seen any build-up to that amount. The valuation of 911,455 that I've carried forward is based on the valuation that AECOM undertook, adjusted for the overheads and profit that will be chargeable to BAM, and that is as set out in Mr. Doyle's witness statement. If we could move on to slide 17, please. The experts have agreed various adjustments that are to be applied to the valuation, or costs, sorry, so let me go backwards. The experts have agreed various costs that have been incurred by BAM in the recovery of the bonding guarantee, the amounts paid to D1, and the amounts paid to D1, but including Affan Building Services. And they are the amounts in the first table on slide 17. We've also undertaken an exercise to break down the costs incurred by BAM in completing D1's works between periods pre and post June. There are adjustments, or two valuations, one including payments to Affan Building Systems, and one's excluding payments to Affan Building Systems. The difference between Mr. Atherton and I is in relation to the dates we use to calculate the cut-off. I have used payment dates, whereas Mr. Atherton, I believe, has used invoice dates. If we move to BAM's claims against D2, that, and this is on slide 19, that is agreed between the experts, and there's nothing really further to address on those slides. If we move forward, please, to slide 21, this is a valuation of D1's works based on either the subcontract price breakdown in the BQ, and also the stage payment schedule. Mr. Atherton has not provided a valuation based on the subcontract BQ rates. It's unclear why. We have the BOQ rates, and we both have been able to verify progress percentages for the 404 panels that have been installed and the 433 panels that have been delivered. I've produced a valuation on that basis based on the subcontract BOQ rates. It can be seen from Table 1 that we both agree the amounts that are to be adjusted to reach a valuation for amounts paid and the advance payment bond. The stage payment valuation is set out in Table 2. So this is based on the payment schedule that I mentioned before that deals with the 31,250,000 for design. And we can see, based on this valuation, that Mr. Atherton values a slightly higher, I value a slightly higher amount than Mr. Atherton, and that's because I value the delivered panels at a slightly higher percentage, in that there are 433 panels delivered and 404 installed. If we could move on, please, to slide 23. This is the original D1 claim that was explained and set out in the particulars of claim. And essentially what we have is the subcontract price, which, as I mentioned before, seems to have been retrospectively calculated, and that is based on panel sizes of 4 by 2 metres. There's a as-built design amount, and across the two we have a adjustment factor, we have a difference, and then we have an adjustment factor, and the adjustment factor of 70% is applied on account of there being an increase to 70% of the panels where the panel size has increased. And that translates through to the valuations in column G, and totals 183, 733, 747.29. If we could go, please, to slide 24. The differences here are out of date on account of Mr. Atherton's amendment yesterday. I understand there may be some further adjustments to some of those figures which will further narrow the differences between Mr. Atherton and I. If I sort of go through very briefly the differences between us, the brackets and supports, it's essentially a rates issue, a small minor rates issue. The foam and milling, if we could move briefly to slide 27, please. The provision of foam is a unit rate issue. The foam milling is essentially to do with a difference in approach to the valuation of depreciation. I value it across 5 years. Mr. Atherton values it over 3. The 5 years is consistent with the price breakdown that was produced in 2016, which refers to equipment having this type of equipment having a useful life over 5 years. If we could move on to slide 28. Sorry, if I may just go back, sorry, that was okay, that's fine. The fibre reinforced materials, this has been subject of an adjustment, further adjustment and revision by Mr. Atherton, and this is, I understand that we are now almost entirely agreed with the valuation of this item, and it may be that there's only one small rate item left where we have a disagreement. And that disagreement, I think, is relatively small, probably one of the small value differences we have. 29 slide, we deal with panel joints. That is now agreed between Mr. Atherton and I. Consumables is a very small difference. Ovens, I've been unable to provide a valuation due to a lack of information. This is on slide 31. I agree and accept that ovens will have been used, but based on the information that I've been provided, I've been unable to complete a valuation as to what that amount may be. Stainless steel, Mr. Atherton and I agree the amount for the provision of stainless steel. I've been unable to agree an amount for machining as I don't have details of the rate build-up, and I'm unable to investigate that rate or take a view on what that rate may or may not include. For stainless steel accessories, Mr. Atherton has revised his valuation and removed an item for overheads and profit. Mr. Atherton's taken the claimant's, D1's amount, which we both agree lacks supporting information, and has prorated that across 404 panels. I've taken fixings and the like, this is on slide 32, sorry, the fixings and the like, and I've valued those at 200mm centres and built a rate up using the ratio that D1 has put forward, but valued them individually to give me a composite rate at 200mm centres. As regards labour for fabrication, Mr. Atherton and I have a difference in the rate to be used to value the labour. Absent details from Affan, Mr. Atherton and I have used BAM's contra charges as a reference for calculating typical market rates for labour. The BAM market rate, or the BAM rates in those contra charge notices include labour supplied by third parties. In my view, if we're going to treat that labour as directly employed, we need to make an adjustment for overheads and profit to any third party suppliers, so we're calculating an effective cost of employment rate. I've taken 15% as a notional adjustment for overheads and profit, and that drives the difference between Mr. Atherton and I in terms of rates. The balance of the difference between Mr. Atherton and I is that Mr. Atherton carries forward a valuation for labour after February. There is no supporting documentation for labour after February, and Mr. Atherton and I have both agreed that the labour that is presented for the period after February is a calculated amount on a formula or forecast basis. That concludes my presentation.
Thank you. Okay, I think we'll just rise for good afternoon break since we're sitting till 5.
Of course.
Okay, well, it's now... we'll come back at 1:45.
Okay. Yeah.
Do you actually take it?
No, I don't think so. But even if you do, I don't think it's kind of ripped. I think.
It's as fancy as something you can get for a £10.
No, they're very expensive. No, they're that brand. Better silk ones, I'm just going to letters in. I'm not really sure.
Sorry that it was rather longer than anticipated, but I ended up in a telephone conversation with the museum authorities. I think the less I say about better on the public record, the better. So it may be that we may have to have our inspection tomorrow at 10 o'clock. So, Mr. Hussain, you're going to, I think, have your cross-examination.
Mr. Kenyon, if we can please take up your slides, it's slide 7, please.
Sure.
It'll just come up. So you mentioned the tender return calculation on the 3rd of September 2016.
Correct.
And you rightly mentioned that the pricing document is based on 9 by 2.2 metre panels, correct?
Yes.
So if we go to the document at 7, combined bundle 747, and then go to page 749. Within that document. (749), please, Terrace. I'm so sorry, Mr. Can you just bear with me? So we see calculation of panel 9 by 2.2.
Yes.
So it's very clear to you that the tender was priced on the basis of 9 by 2.2 panels, correct?
That's what this document shows.
Okay, thank you. Then if we can go to your slide 11. There's a remarkable and laudable degree of agreement between you and Mr. Atherton on the claims figures, yes. And if we just look at one of the few items, it's quite a small item, item 10, there's an adjustment for a negative variation.
Yes.
And that's not agreed. And I just want to look at that in terms of the approach. So if we go to your report at file 17, page 10. Just bear with me. Come on.
Is this my second report?
Yes. 2.9. Yes, this is that item we were looking at. The
what page is that on my report, please? So I can't see.
Page 10.
Okay.
PDF page 10, 2.2.9.
It's both the PDF and internal page 10.
Okay.
You there?
I am, yes.
So you're talking about this item, and you say in MK1 I provided a valuation of negative 911,000
Yes.
AD in respect of the emission of the sandblasted edge to the glazing.
Yes.
Mr. Atherton has not provided a valuation of this item. In GA2, Mr. Atherton says that he has not been provided with any valuation of this item by Affan, and that he has been unable to locate a copy of the employer's cost consultant's assessment. You then say, in MK1, I noted that the employer's cost consultant's ACOM's assessment was provided as part of DD2. That's Mr. Doyle's second statement.
Yes.
I also noted that in DD2, Mr. Doyle says that ACOM's, next page, assessment represents a full amount to the claimant by the employer's cost consultant. I provided a valuation by reference to the ACOM assessment.
Yes.
So that assessment is at page 2695 of the combined bundle. If you can, is this a document you've used, Mr.
Bear with me 1 second. So I'll go to where my valuation is.
It says, if you scroll down, please, Teres. Yeah, if you pause there. See the reference. Sorry, go up.
Yes, that's it.
Go up, please, a little bit, Teres. There, pause. Omit sandblasted edge to glazing. Is that what you use?
It is, yes, because that's the one with the manuscript notes, yes.
So I think it's fair to say that there are items where you or Mr. Atherton may not have the ideal backup, but you would like to interrogate the figures yourself. And where that's the case, you very correctly have said, this is what I have and this is what I've put in. Is that fair?
That's in relation to this item, yes.
Okay. And Mr. Atherton has done that for a number of the items where there is still a dispute between you. So he's put in a headline figure, but you both agree that there's nothing behind that figure.
Correct.
So then it's a matter for the
Evidence.
court. Yes, thank you. That's really helpful. So that's on the approach. Just to kind of look at some of the other helpful items that you and Mr. Atherton are agreed on. If we go to file 22 and the second joint statement, at page 8, just bear with me, it'll come up. That's it. Just bear with me one moment. Sorry, it's the first joint statement. I'm so sorry. It says file. File 19. I'm so sorry, Mr. Can you just bear with me a moment? Page 17, I'm so sorry. Your Honour, you're gonna, I have a confession to make that my laptop is frozen, so I'm using Mr. Blakeway, so do bear with me. No, sorry, it's the same document. I'm so sorry, Mr. Kenyon. First joint statement, which is at file 19, at PDF page. Just going. Right, we're getting there. I'm so sorry, Mr. Kenyon. I'm sorry, Your Honour.
It's okay.
If we go back to file 22, apologies, Teres. File 22, second joint statement.
Sorry,
I'm so sorry, Your Honour. Is the second joint statement.
So we are back at...
Yes. Hopefully this will be the last of the hiccups. Fingers
Okay,
crossed.
and page...
Page 9.
Page 9. Okay.
There we go. I'm so sorry, Mr. Kenyon. So I'll wait for Your Honour to catch up, or to get there, sorry.
Okay.
So you see the table in the second joint statement of 4.1.1. You and Mr. Atherton agreed that the sum recovered on the advance payment and performance guarantees is 21.875 million, yes?
Yes.
You also agreed that the amount paid by BAM to the first defendant is 46,509,103.14.
Yes.
And then you've also included...
Sorry to intervene, sir. I request the witness to turn on his mic and speak, please.
Yeah, the microphone's on.
Yes, sir.
Thank you.
And you are, if you look at item, so that's item E, and then item G is if you include, or if you add to that figure at item E, a payment made to a company called Affan Building Systems LLC, then you agreed that the payment made is 54,357,210.80. Yes.
That is correct.
Okay, that's useful as a parameters. If I can then hand up, or if we can bring up as well, please, the presentation that Mr. Atherton will give shortly, simply because that updates the figures and reduces the differences between them.
Thank you.
No, sorry, can I give this to the judge? And if we go within that to page 8. So the reason I'm using this rather than the one in your slide is that there are some corrections made, I think, yesterday to Mr. Atherton's figures, which narrows the differences between the two of you on this as-built valuation, or what you've called an as-built valuation.
Yes.
We have your evidence on what that means and so on from your point of view. But just to give the court an idea, on this method, the total from Mr. Affan is 66 million, and the total from you is 55 million. You see that?
Yes.
So it's roughly 11.7 million difference.
Yes.
And the largest items of difference are item 2, foam and foam milling. And then there is fibre reinforced materials, on which I understand that there is a prospect of further discussion between the two of you.
Yes, I'd be surprised if that's not fundamentally agreed with,
Okay.
or a small difference.
So I'll put an asterisk against that. And then the next big item is the ovens. Now, with the ovens, I think I can be quite blunt. The point is that Mr. Atherton has just taken forward a figure that was in the claim.
Yes.
And your evidence is, yes, you accept that there would have been ovens and some cost, but you have nothing to go behind that figure.
Correct.
And Mr. Atherton accepts that there is nothing to go behind
Correct.
the figure at present. Okay, and then the next big item is the stainless steel, which I'll come to in a minute. And then finally the labour for fabrication, which you helpfully spoke about in your presentation and was the subject of a further report and some further documents that were produced.
Correct.
So really if we're looking at the big items, it's the foam milling, stainless steel and the labour for fabrication. I'm assuming that you and Mr. Atherton may, fingers crossed, speak further on the fibre reinforced materials. And on the ovens, there's not much more to say other than there's a figure and nothing
Correct.
further. Is that fair? Is that a fair description?
I think that's fair, yes.
Okay. So with that in mind, and again, you're both to be commended on a very clear joint statement, which, to the extent there are differences between you, explains them quite well. So if we go to the looking at the foam and foam milling, if we can go to the first joint statement, file 19, page 32. Sorry, it's the first joint minutes, which was.
Can I have a reference, please?
You're on its file 19, first joint minutes at PDF page 32. Excellent. Can we scroll up to page 32, please? Yeah, that's it. Thank you so much. So we have if we can just see the top of the table, please, operator, as well. Just one line. Thank you so much. So we have item F, which has a summary reason for difference, and if to the extent there's an agreement, that's normally where it's noted, and then both you and Ms. Atherton have given your comments, yes?
Correct.
So if we look at the provision of foam, what it says is that you've agreed the quantities.
Yes.
And there is a difference of roughly 500,000, 538k between you, because you're using different rates. That's correct, isn't it?
That's correct.
And what this can be the subject of written submissions, but Mr. Atherton, if you look at his comments, has based his valuation on the rate in a particular purchase order with a firm called, or supplier called Polychem. And you, I understand, have used a blend of rates, but in doing so, you've looked at what BAM paid, because BAM purchased some foam as well. That's part of its claim.
Yes, during the time when they were, I think before the taking over, when they were purchasing foam on behalf of BAM, I think, on behalf of D1, yes.
But the rate BAM paid for the foam, and if it got a better rate than what Affan did, is not relevant to the question of what Affan should recover, is it?
No, I mean, we have a purchase order for some foam, which is the rate that Mr. Atherton has used, and I've gone and looked in a deeper sense at the rates that were generally being paid for foam at that time, and the rates that I've seen are broadly consistent with the rate that D1 is valuing, and on account of that I've carried forward the rate that D1 had applied. So my rate is D1's rate that I felt was consistent with the overall blend of rates that were presented or that I've analysed in my first report.
But you'll agree with me that as a matter of interrogating the quantum, what BAM paid should not be relevant to determining the cost paid by Affan.
Well, what I've done, I've tested the rate that was being valued by D1 of 1098.11, and I found that to be consistent with the rates that were being valued by BAM during the period it was providing foam to D1. So I'm happy that that's a reasonable rate to be used, and the purchase order rate is just for that particular purchase order. It's not necessarily the rates that were being paid for all of the foam. So I think, again, the rate that I've used is consistent with D1 for the reasons I've explained.
Okay, well, we have your different positions, and we can take submissions on that. Then if we look at there's two items to the foam. There's the actual purchase of the foam, and then there's the foam milling cost, yes?
That's correct.
And if we scroll down, please, on that useful table in the first joint statement. Just looking at the table on the top, if you scroll up a bit, although there's a limited difference between you and Ms. Atherton on the provision of foam, which is based on the rates.
Yes.
There is a more significant difference between you on the foam milling, yes? You see that?
Yes, exactly.
And then you explain the reason for that difference under the headline foam milling in that useful table. It says your valuations are based on the same quantities hours, but the difference relates to the hourly rate for foam milling. Mr. Atherton values an hourly rate of 458 dirhams, whereas Mr. Kenyon values an hourly rate of 198.64 dirhams. And then if you look at the breakdown of that rate is a function of essentially the costs of the milling equipment and various works involved with setting up that equipment, yes?
Correct.
So you are agreed on perhaps the largest single item, the purchase cost of the machine, so not agreed.
Yes.
You're not far off.
That's correct.
On the purchase cost of the machine head.
Yes.
But then if we look at the item called base setup including steel structure, the 1.267, Mr. Atherton has allowed the claim sum whereas you've allowed 0.
Correct.
And if we scroll down, similarly, there are other, sorry, we're looking at the, so the top of that page, item 4, item 6, 7, and 8. The figures are from essentially the claim, and you said you've not been able to go behind those figures. So my understanding is that for the, sorry, am I going too fast for this to be?
No. This is fascinating.
I'm sure. Well, it's one of the good things about a high level of agreement between two quite reasonable experts. So on this, if we go back up a page to item 3.
Yes.
So item 2, Mr. Atherton says that he has seen a quotation for one of the items that goes to the build-up of the 1.267.
Yes.
And your point is, well, the quotation is all you've seen, and you've not seen anything else for the other items.
Yes.
Okay, so then it's a question of whether that satisfies the evidential burden for this item. Okay, on the next large item of difference, we go to the stainless steel, which is, bear with me, I'm assuming you gentlemen will speak about the fibre reinforced material. And I've already taken you as far as I can with the ovens. So if we go to item 8 in this table, which is at page 35, I understand.
Yes.
Sorry, scroll down, please, Terrace. Scroll down. Thank you. Item 8. Page 36, I'm so sorry. So on this one, for the accessories, if we go to, so that's where you've put in 210, and Mr. Atherton has put in just over 1 million. Mr. Atherton, I understand, has just taken forward the claim figure.
No, he's done something slightly different. He's taken forward the initial figure and then prorated it to arrive at a figure of about 800,000, which he then adds 16.9% to. In his updated valuation, he corrects, he removes the 16.9, so we don't have a duplication. What I've done,
sorry, that is
and for me, I've taken the components and valued them at 200mm centres across the surface of the panel.
That's very fair, Mr. Kenyon. I'm grateful for your clarification, and you're correct. If we just look at page 37, you explain that you've, in the absence of supporting information, you've calculated a provisional rate based on fixing studs at 200mm centres across the area of the stainless steel cladding. And then if we go to the last item in terms of the large items of difference between you on the as-built, what's called the as-built valuation, if we look at perhaps we can look at your slide 33. That might be the easiest way to do that.
Yes.
So in terms of the differences between you and Mr. Atherton, there is an exhibit that was provided that showed the man hours recorded at the time.
Yes.
Dividing them between labour provided by BAM.
Yes.
And when I said provided by BAM, I mean through suppliers.
Correct.
And labour provided by Affan.
Yes.
And that, one of the big differences is that only goes up to February 2019.
Correct.
And what Mr. Atherton has done is he has prorated, to use it.
I wasn't aware Mr. Atherton had prorated it. I think it was already.
Okay, so he's taken the forecast, sorry.
Yes.
He's taken the forecast and taken it forward.
There was quite a complicated formula that was used to fill in the amounts for March, April and May.
Okay, and then that accounts for part of the difference in that you've said, look, you're not comfortable taking man hours for February 2019.
I've provided an alternative valuation that corresponds with the hours that Mr. Atherton has put forward.
But for your primary one, that's one
Correct,
of the differences.
yes.
The other difference is in terms of the rate. Now, what both of you, I understand, have said is that you can see a rate claimed by BAM for labour.
Yes.
Mr. Atherton has used a particular rate of 25 dirhams.
Mm-hmm.
Your point is that the rate varies, so you would like to, you blended the rate.
No, I think we both use a blended rate.
Okay.
So Mr. Atherton, there are contra-charge notices. I think 1, 2, I forget exactly how many. Mr. Atherton takes the total labour cost from those, divides it by the number of hours, and gets a rate. Whereas I'll step one step further back. We don't have the costs for Affan. So what we've had to do is use equivalent market rates to be able to provide a valuation. So we've used the rates at the time that BAM had for its labour that it was contra-charging to Affan as being reflective of market rates. So Mr. Atherton has added all the labour up and divided it by the hours to arrive at his rate, and then added 16.9%. What I've done, where there is a third-party supplier, so we can effectively have an equivalence of what would be the cost of employment directly, I've taken a notional allowance for overheads and profit off the suppliers. So we effectively have, this is the net cost of employment if they were employed, and I've blended that rate with that adjustment into the direct BAM labour to get a equivalent cost rate. That's the difference between Mr. Atherton and I.
That's really helpful, but so it's fair to say, and I think this is probably a matter that's better dealt with in written submissions, that a large part of the difference in the figures and the rates is that you've removed an element of overhead and profit, which you understand, which you say would be.
Yes, if I'm a subcontract, if I'm applying subcontract labour to whoever it may be, my rate necessarily includes overheads and profit. Where if I've already got that labour on my books, I'm not paying a third party's overheads and profit. So when I then add overheads and profits in on a gain, which happens at the second from the bottom line, there is a duplication. So that's why I've removed the 15%.
I understand what you've done, but Affan was also using labour suppliers, so it would have had to pay them an element of profit on a market rate.
I don't know. That's not something that I've looked at.
Okay, thank you. We just bear with me. Oh, sorry. Yeah. Just bear with me one moment. So we can go to your slide 21, please.
Yes.
So table 1 is, I understand, well, you've got the reference for it, but it's a table in your first joint statement, I believe, or second joint statement. Yes.
It's the first, yes.
First joint statement. So what both you and Mr. Atherton have carried out an exercise where you have looked at applying Annex 3 to the subcontract to come to valuation, yes?
Yes, I provided an equivalent valuation to the one that Mr. Atherton first put forward, yes.
And I take your point that you say that that might not be the correct method. That's a question of contract. But in doing that, in doing a like for like, you're not far off in terms of your valuation. Yours is 75.6 million. That's the top table.
Yes.
and Mr. Atherton's is 73.9 million.
Correct.
And then you have carried out a valuation of progress against subcontract bill of quantities rates.
Correct.
But that's not something that's in Annex 3. That's an exercise that you've conducted on...
Yes, I think as I alluded to in my presentation, I passed my opinion on the use of the stage payment schedule, the BOQ rates, as an alternative way of looking at the evaluation of progress that doesn't essentially suffer from, I don't mean this in a negative sense, but from the loading of rates that would appear.
But on the other hand, you said that the bill of quantity rates have no breakdown.
Correct.
So, I mean, for all one knows, they could have been filled in to justify the contract price rather than actually represent anything.
Well, I think they do have status in the sense that they're there to be used for the valuation of variations.
Yes.
So they have obviously some standing.
Yes, on that, if we go to... I don't want to put you on the spot and debate the contract with you, but just to get some understanding of the limitations of that document. If we go to page 1436 of the combined bundle, this is the subcontract. It says the value for all subcontract variations shall be ascertained by reference to the rates and prices, if any, specified in the subcontract for the like or analogous work. But if there are no such rates and prices, or if they are not applicable, then such value shall be such as is fair and reasonable in all the circumstances. There is no rate or price for larger panels than 9 by 2.2 in the subcontract pricing document.
I don't know, I'd have to check.
Okay. That's very helpful, Mr. Kenyon. That's all I have. Thank you.
Okay, thank you.
Thank you very much, Mr. Hussain. Lord Marks, any re-examination?
I have no re-examination.
Thank you very much indeed, Mr. Kenyon. All very helpful. Thank you. I think we've got time, have we, for Mr. Atherton to make his presentation?
Yes, of course.
Meanwhile, can I just find out whether we're on for tomorrow? If it will pop out and check. Thank you. Is Mr. Atherton going to take the stand?
Yes, sorry, sir. Please.
So I've got a hard copy already of Mr. Atherton's slides to introduce his evidence onto the record.
Yes, sorry, I thought it was going to be... We're not swearing in the experts, is that right?
Oh gosh, yes. We'll swear. Perhaps we'll swear him in.
Sorry.
In order to save time, sorry, I sent the associate there to find out whether our site visits on tomorrow. Will you make your presentation, then we'll swear you in, and then we'll put your evidence on the record, all right?
Okay, thank you.
Save us a bit of time.
Terrace, can we please bring up Mr. Atherton's presentation, which you should have?
But please give the reference, sir.
You could try.
Will it be in file 23?
That's the correction.
It's down. Go further down. Using, that's it. Yeah.
Great. Well, Mr. Anthony, if you just present that.
I will be brief, Your Honour. I think Mr. Kenyon has covered most of the same points that I wish to cover anyway.
You have to speak up a bit as well, I think.
Okay, so if you can go down to the next page, please. I think we've already been through the first sheet here. This is a summary of the BAM costs, which are mainly agreed. As was pointed out during Mr. Kenyon's cross-examination, there are two small issues which are not agreed. One relates to the costs incurred after the 31st of October 2021. There's a small amount of 54,000. The main item that is not agreed is the variation for the emission.
Would you bear with me 1 second? I'm sorry? They're still being difficult. The museum is still being slightly difficult, I'm afraid, in terms of our site visit tomorrow. Actually, would you? So, in which case, let's swear Mr. Atherton in now. In that case, then. Sorry, I've messed you around, Mr. Atherton.
Can you please confirm whether you be swearing by oath or affirmation?
By oath.
Thank you. Please confirm your full name and occupation for the court's record.
My name is Graham John Atherton. I'm a chartered quantity surveyor.
Thank you. Please repeat this card.
I swear by Almighty God to tell the truth and nothing but the truth.
Thank you.
Thank you. I'm sorry for that.
No problem.
Do carry on.
Yes, sorry. So the main item on the BAM costs, which we have not agreed, relates to the variation for the omission of the sandblast etching from the glass. If we could move to the next slide, please. The main reason that I haven't undertaken a valuation of this particular omission is that the documentation that I have looked at contains an unsubstantiated provisional variation which was prepared by the employer's cost consultant, and I have not seen any evidence as to the actual value of the work omitted under the main contract. Next slide, please. In terms of the valuation that we've carried out under the subcontract, the payment terms are contained in Annex 3 of the subcontract. This confirms that an amount of 31,250,000 of the agreed subcontract price for design works. There is then a percentage against progress for completed panels delivered to site that are not installed at the end of each month at 70%. And then the balance of the subcontract price is paid progressively on a pro rata in accordance with the progress of installation. That would be the remaining 30%. Next slide, thank you. As we've already discussed, has already been discussed during Mr. Kenyon's cross-examination, we have both undertaken to produce a valuation of the work completed in accordance with the payment terms under the subcontract. And at the moment, on the stage payment schedule, there is a difference between us, only very slight. Mr. Kenyon has valued it at 75.6 million. I have a valuation of 73.9. Mr. Kenyon has also provided a valuation based on progress against the subcontract BQ rates.
Yes.
I haven't done that simply because it's not the procedure that's set out in the subcontract. The main reason for the difference on the stage payment valuation, my valuation is based on 404 panels delivered and installed. Mr. Kenyon's valuation is based on 433 panels delivered and 404 installed. I believe there is evidence available to suggest that 433 panels have been delivered. However, I was only provided with delivery notes for the 404. I do provide an alternative valuation for the 433 and 404. Next slide, please. I think we've already discussed this, so we can move on to the next slide. We've already discussed Mr. Kenyon's valuation on the progress and why I didn't do so, so we can move to the next slide. This is the current summary of the as-built valuation of the progress achieved by Affan. This contains the updated figures that I issued in my correction yesterday.
Yeah. And Mr. Hussein's taken us to this already.
And Mr. Hussein has already taken us to this, so we've already discussed the main areas of difference during Mr. Kenyon's cross-examination, and I'm sure I will be asked more questions on it very shortly. So if we can move on to the next slide, please. One issue that we have both been unable to value is D1's claim for the design and production management, site management and installation. This is due to a lack of evidence provided to substantiate the costs claimed. However, I am aware that an amount of $31,250,000 has been certified and paid to D1 under the subcontract, and I do believe that this amount should be considered in the valuation of the work completed by D1 in the final valuation.
But as I understood Mr. Kenyon's evidence, it is possible that included an advance payment on actual production.
It is possible, yes. I would have to look at that, yes.
Okay.
Next slide, thank you. In terms of the method of valuation that both myself and Mr. Kenyon have adopted, we have, for the reasons that Mr. Kenyon explained, not used the IFC base calculation as was the method put forward by D1 in preparing its claims. What we've actually done is looked at the value of the work actually executed by D1 and valued it on a cost plus basis. We've verified costs insofar as we've been able to, based on invoices and evidence of payment where that's been made available. By way of example, using the fibre reinforced materials, at paragraph 2568 of my supplementary report, I state that I've been provided with a copy of an LPO issued to Notus Composites for the project, together with several invoices issued to Affan for the same materials, and I've exhibited these at SQER 34. This exhibit contains the LPOs and a number of invoices from Notus for the materials. The cost rates I have used for calculation purposes, and I've added overheads and profit to around invoices from Insultherm and Smithline, who were the supplier of foam to BAM.
Okay.
Foam milling, hours are agreed. The rates are the main issue again. As was discussed during Mr. Kenyon's cross-examination, the main issue here is the calculation for the concrete base. And apart from a quotation from High Roofs contracting for the concrete for the base, which is actually quite a small proportion of the overall valuation, the remaining items we have no information and remain subject to further verification. I've also made a note there of where that High Roofs quotation is contained within the defendant's disclosure, because I think Mr. Kenyon made the comment that I may have not referenced, provided the exhibit with my report. So I hope that helps. Again, due to the lack of information, Mr. Kenyon has not valued this. We have a slight difference on the depreciation. I have used D1's calculation, again subject to further verification, and I understand that Mr. Kenyon has undertaken a different assessment based on some information that he has located in the tender submissions. Next page, please.
So Mr. Kenyon was reasonably optimistic that fibre reinforced materials could be agreed.
Yes, I've had a discussion with Mr. Kenyon this morning. I have looked at the calculation. I'm reasonably optimistic that it can also be agreed. I do have another question from Mr. Kenyon, which I can discuss with him.
Yeah, well,
and hopefully settle that matter.
Yes, agreement is best of all.
Yes, I think we can get that one agreed. So
okay.
I won't cover that. Ovens, I think both myself and Mr. Kenyon agree. There is just a complete lack of evidence with respect to the cost of the ovens. However, I took the view that based on the delivery and installation records that we have available, panels were continuing to be produced, delivered to site and installed, and common sense tells me that on that basis their ovens must have been used for curing those panels. I do understand that there is a lack of evidence, But I have used D1's calculation to value the cost of the ovens for the 404 panels that I said have been delivered and installed, again subject to further verification. And I am continuing my investigations to see if there is actually any further information available in respect of the cost of the ovens.
Okay.
I understand the basis that Mr. Kenyon has not valued this due to a lack of evidence. Next page, please. Again, this has already been discussed during Mr. Kenyon's cross-examination. The stainless steel, there is a slight difference on the machine time. I have calculated the average machine time as 11 minutes and 5 seconds per metre squared. Mr. Kenyon at 10 minutes and 51. So that produces a slight difference. Rates, generally a lack of supporting evidence. Again, I have used D1's rate subject to further verification. Mr. Kenyon has not valued this due to a lack of evidence. Stainless steel accessories, we agree the quantities, they're as per the shop drawing. Again, it's an issue on rates, generally a lack of supporting evidence. I've used D1's rates again subject to further verification, and I understand that Mr. Kenyon has calculated a provisional rate for the purpose of his valuation, which I'm sure we can reach some agreement on.
Good.
Next page, labour. This was pretty straightforward, as I think you probably heard during Mr. Kenyon's cross-examination. I have included the forecast from March 2019 to May 2019. I undertook to review the forecast in terms of the quantity of work that was left to complete, and I thought that the hours were reasonable. There is a very complicated calculation as to how they've reached the forecast, but in my opinion it looked like a reasonable forecast. I understand that Mr. Kenyon excludes those hours but has provided an alternative, so we would effectively agree the hours on the alternative basis.
Okay.
The issue on the rates is the deduction for the overheads and profit from the third-party labour suppliers. Mr. Kenyon has made an allowance for that. I have not. I haven't seen any evidence to support the assumed level of overheads and profit for the suppliers, and I would need to consider that if D1 was in the position where he was having to employ third party to supplement his labour, he would possibly be having to pay them the overheads and profit as part of the cost to D1. So
Okay.
I've included it.
Great, thank you very much. That's
I think
very
that's
helpful. Right, Lord Marks.
Oh, yes, but I thought he was going to put in his evidence.
Oh, I'm sorry, yes, you're
Oh, yeah, we
absolutely
have-
right.
yeah.
Might as well put it on the record, yes.
So if we can go, please, Mr. Affan, to file 12, please, Terrors. And you have your first report. Do you recognise that as your first report? If you scroll down, please.
Yes, it
If
is.
we go to page 92. Is that your scroll up, please? There's a statement of truth and a signature. Is that your signature?
It is.
And subject to the corrections you've made, is this report true to the best of your knowledge and belief?
It is.
We go then to file 16, please. Let's see your. Do you recognise this as your supplementary quantum expert report?
Yes, it
the
is.
5th of July.
Yep.
Go to page 105. You see a statement of truth. Is that your signature below?
Yes, it is.
And subject to the corrections you have made, is your evidence in the second report true to the best of your knowledge and belief?
Yes, it is.
You're going to then go, please, to file 19, the first joint minute. You recognise that as a first joint minute that you created with Mr. Kenyon?
Yes.
Go, please, to page 42. Is that your signature?
Yes, it is.
And insofar as you've stated your opinion and subject to the corrections you've made, is your evidence in this first joint minute true to the best of your knowledge and belief?
Yes, it is.
We then go to file 20, please. Do Do you recognise that as your second supplementary report on the 25th of September?
Yes.
Go to page 15, please.
Third report, isn't it?
Yes, it's called second supplementary, but it's a third report. We see a statement of truth with a signature. Is that your signature?
Yes, it is.
Subject to the corrections you've made, is your evidence in this report true to the best of your knowledge and belief?
Yes.
There's two more, so bear with me. We go to file 22. Do you recognise that as a second joint minute that you created with Mr. Kenyon?
Yes.
We go to page 23. Is that your signature?
Yes, it is.
And insofar as you've expressed opinions in the second joint minute and subject to any corrections you've made, is your evidence in the second joint minute true to the best of your knowledge and belief?
Yes.
And finally, tab file 23. There should be some errata. There it is.
Yep.
That's it. GA correction. There is a correction to the quantum expert report, and on page 8, there's an expert statement. Is that your signature?
Yes, it is.
And are the corrections made in this document true to the best of your knowledge and belief?
Yes, they are.
Thank you.
Thank you for that. Sorry about that, Lord Marks.
Right, well, not at all.
Okay, we've got 14 minutes.
Well, yes. Let
Is
me
that
start
enough,
by-
or do you want to start tomorrow morning? It's up to you.
Well, I'm happy to cover a few issues in the 14 minutes.
Okay, as you wish.
The first one is this, really. It's you are officially, of course, in PERDA in this draft.
Of course, yes.
But you've said during the course of your presentation that you thought there were a number of issues that you could agree with Mr. Kenyon.
Yes.
And indeed, Mr. Kenyon said in the course of his presentation there were a number of areas where he thought you'd reach agreement.
Yes, he did.
If you're released from PERDA this evening, which I suggest you probably should be, subject to what his honour says, could you talk to Mr. Kenyon and try and reach as much agreement as possible before tomorrow morning?
Yes,
so
indeed.
that we can then proceed with the cross-examination without running into difficulties over areas that you're
Absolutely,
now agreed
yeah.
on. Well, let's move on from that. That's very helpful. Thank you. The second joint statement, production costs, page 5, line 3. The second joint statement is at divider 22. Page 5, please. One more page. It's the page with the production costs on it. I had it as page 5.
Is the next page, that's PDF page 5.
Yes,
So you want
no,
internal
numerical
page 5.
Yeah, I'm so sorry, yes. So I'd like you please to look at production costs. The agreed valuation is 173,658. But that is on option 1. And that's items where...
To provide a valuation in the period up to the point where BAM took over the works, just to see what the difference was between the costs that D1 had actually requested BAM to pay for, and there were costs incurred in that period where there is no PPR, and I just wanted to see what the difference was between those that D1 had requested and those that they hadn't requested. I understand that that is not the case that's being pleaded. I provided it as an option only.
So an option really that you would be quite understanding if the court rejected it.
Absolutely.
Can we move on then, please, to item 5A and 5B? This is all to do with the CMS costs of the new machinery. And I think the 5A relates to the glass washing machine. And the question is, and it's not a huge amount of money, but it's whether that should include the spare parts or exclude the spare parts. it's right, isn't it, that the spare parts were bought with the machinery?
Yes.
And delivered to Affan?
Yes.
And paid for by BAM?
Yes.
So there's no reason, is there, that they shouldn't form part of BAM's claim?
No, there is no reason. I think the alternatives are agreed on that matter.
Coming to the next one, which is the finance and miscellaneous costs, or it's described as that, but actually this is the whole of apart from the spare parts, it's the cost of the CMS SPA machinery, which was paid for under the Memorandum of Agreement.
Yes.
And you haven't allowed for that in your primary case, but you've allowed for, or you've said the alternative, you agree the amount.
Yes, I agree the amount in the alternative.
We know it's been paid, and it marries up, certainly when you take into account the bank transaction record, with the amount in the euro amount in the Memorandum of Agreement.
Yes, when I first looked at that, I was struggling to find the substantiation for that. I could see some bank transfers from ABN AMRO, I think it was, if I remember correctly.
It was, yes.
And that was really all I had, and I couldn't really correlate those payments with the cost of the CMS machines. I've since had a look at that, and as I say, in the alternative, I think we've agreed those figures.
Yes. Can we go down to line 7? This, again, is a very small difference. Is this down to a
I think we've gone
dispute
down too far.
between your disputer?
I think we've gone down the page too far. Item 7.
Item 7, yes, I'm so sorry. I had looking at my notes rather than the... so is this not agreed 54,000 dirhams, not a great deal of money.
No.
But what we're...
That's something I can discuss with Mr. Kenyon this evening. I'm sure we can work 54,000 out between us.
I'm sure you can.
Cost more to argue about it.
Well, we'll move on then, please, to the agreed price of the subcontract works adjusted for instructed variations at line 11. This is the sand-blasted etching point. And I think you agree first that the sand-blasted etching was omitted.
Yes.
You agree that was a variation, and you've allowed nil for that variation.
Yes.
And that was really as a result of a lack of substantiation, is that right?
It is, yes. I understand that BAM originally valued this emission at somewhere around 106,000, and then the employer's cost consultant stepped in, made some comments on that valuation, seemed to suggest that the basis upon which BAM had valued it was incorrect in terms of the coverage of the glass that was being measured, and also that the rate was significantly lower. There is a handwritten note on BAM's valuation, which basically states that the cost consultant is making a provisional valuation, which amounts to the 911,000.
That's the 911,000.
I do understand there's a lack of evidence. I also understand that this was referred to by Mr. Doyle in his witness statement.
Do you also understand that 500,000 was accepted by Affan? Would you go, please, to the combined bundle at page 1735? You see there were glass. This is the letter of the 29th of October 2018 from Affan. It starts at 1723.
Yes.
And in red writing there, emission of sandblasting to number 1, item 500,000.
Yeah.
So that Affan's position was that 500,000 should be allowed to
Yes, that's correct.
and the employer's cost consultant said 911.
911, yeah.
So it may be that you and Mr. Kenyon can agree somewhere in the middle. We'll see. I'll press on to EJM2.
Well, I mean, is that a convenient moment? It's only...
Wherever it is. It's only 4 minutes to go.
Let's just take stock where we are
yes.
At the moment. So, Mr. Anderson, I'm afraid you are obviously giving evidence. You can't discuss your evidence with anybody but Mr. Kenyon.
Okay.
If you can agree stuff with Mr. Kenyon,
yes,
that will be fantastic. Thank you very
I'll
much.
do my best this evening.
Well, may we have permission to have a report back?
Yes, from Mr. Kenyon. Yes,
from Mr. Kenyon and
yes.
I think from Mr. Atherton.
Yes, yes.
So that we can proceed on the basis of agreements.
I think that obviously that's right. So let's just take stock. At the moment, we do not know whether the museum is willing to permit us to have our site view tomorrow. So we will reconvene at 10 o'clock. I think the first order of the day tomorrow is Mr. Hussein's response to your application for further disclosure. So I'll deal with that first. We hope to be able to give you an update in terms of the visit, if it's going to happen. We'll then, of course, deal with the remainder of Mr. Atherton's evidence. And subject to whether or not we are going to have our view, I would then, as I said, perhaps like half an hour to an hour conferencing with the architectural experts, as I said, just following really the scheme of their joint statement and the issues that are highlighted there as their differences. Again, for the benefit of both experts, what I'm particularly interested in is the feasibility of the initial tender, which is an element of disagreement, and the genesis of the hexagonalization. Those are the particular issues that I want to discuss with the experts. Anything else?
Well, may I just make a suggestion?
Yes.
It's provision. In the event that the visit doesn't go ahead,
yes,
both experts, Ms. Kinderland and Mr. Smith, would be quite happy to deal with a view while they're here, even if it's after tomorrow.
Okay.
And Horizon and DLA Piper could attend. So I don't think it would.
What you're asking me to say is, do I mind if neither you nor Mr. Hussein attend any view later in the week?
I am asking that.
Yes, and the answer is no, of course I don't.
Because we're both, I think, hoping to get on a 4 o'clock flight tomorrow. But
well,
that may not be possible.
It may or may not be possible, yes. But either way, if your clients are happy that leading counsel don't attend, then that's fine by me.
Rana, thank you very much.
Your Honour, as I indicated, I'm going to be seeking instructions on the items that Mr. John Marks has asked for, so I will report first thing tomorrow morning.
Okay, superb. Thank you very much. In which case, I will see everybody at 10 a.m. tomorrow, and we'll see where we get to. Thank you very much. Alia, there's a lady at the back. Would you show her and her colleagues through to the boardroom, please? Thank you. All right.
Do you need anything from the room? Yeah, please, because we're going to have to sit there. No, you need to speak first for 10 minutes. Can we just, is she on her way now?
She's on her way. She just wants to know when she's going. So we need to hear regarding to what I'm saying.
I really can't. Can she just wait 10 minutes and then we'll instruct her?
Yes.
waits can be rather a long wait.
What's your